Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today may be the day I earn your subscription. So thanks everyone for joining us for another episode of Supreme Court React. For those of you who are newer to the channel, this is an opportunity for us to listen to oral arguments at the U.S. Supreme Court on a case that I find interesting. And I've chosen for our case today to pick Shurtleff versus Boston. Let me read you the description of the case, courtesy of oye.org. The facts of the case are these. The City of Boston owns and manages 3 flagpoles in front of City Hall, the seat of Boston's municipal government. Ordinarily, the city raises the U.S. flag and the POW-MIA flag on one flagpole, the Commonwealth of Massachusetts flag on the second flagpole, and its own flag, that would be the city's flag, on the third flagpole. Upon request and after approval, the city will occasionally fly another flag for a limited period of time instead of its own flag. Gregory T. Rooney, Commissioner of Boston's Property Management Department, reviews the applications for flag-raising events to ensure the flag is consistent with city's messages, policies, and practices. The city has approved 284 flag-raising events over a 12-year period, and Rooney has never denied a flag-raising application. Camp Constitution is an organization that seeks to, quote, enhance the understanding of the country's Judeo-Christian moral heritage, unquote, and applied to fly a Christian flag for its event. Rooney denied Camp Constitution's flag-raising request, finding it was the first time any entity or organization had requested to fly a religious flag. Camp Constitution sued, and the district court found for the city. On appeal, the U.S. Court of Appeals for the First Circuit affirmed. Thus, the question presented, does Boston's refusal to fly a private religious organization's flag depicting a cross on a city flagpole violate the organization's First Amendment rights? So as the description indicated, the city has a flagpole which it normally flies its own flag, but upon request will fly the flag of others. And up till now has never said no. The first time it ever said no was for the Christian flag. So we're going to, for those of you who are unfamiliar with the Christian flag and what it is a white flag, and in the upper left corner is a blue part on which is superimposed a red cross. So the majority of the flag is white. And in the left corner is a solid field of blue with a red cross. So that is the Christian flag they're talking about. So we are going to analyze this case by listening to U.S. Supreme Court's oral arguments. So let's go ahead and get started with that.
We'll hear argument first this morning in case number 20-1800, Shurtleff versus Boston, Massachusetts. Mr. Staver.
Mr. Chief Justice, and may it please the Court. After 12 years with 284 flag-raising approvals, no denials, and usually no review, one word caught the attention of a Boston official, the word Christian on the application. The flag itself was not the problem. Had it been called anything but Christian, the same flag would have flown for an hour without incident. The policy does not limit the flagpoles to subject matters or speakers. All applicants are welcome, except religious viewpoints. The 2018 codification places religion in the same category as speech deemed inappropriate, offensive, supporting prejudice, or discrimination. To support its admitted viewpoint discrimination, the city raises one defense, that the public forum open for all applicants is really government speech. This court warned in Rebuttal that the government speech doctrine is susceptible to dangerous misuse. This is such a case. The city's flag-raising forum is not government speech under Walker and Summum. The city, by an unbroken history and practice and policy, expressly declared that the flagpoles are one of its public forums open to all applicants. In doing so, the city long ago crossed the line from government speech to private speech. A reasonable observer would understand this history and the policy. This observer would also see a private event coinciding with a temporary flag-raising event. The city exercised no control over the message, the design, and did not own the flags. The city never requested flags or messages to be changed and usually did not review them. The city's application alone cannot transform private speech into government speech. In light of the practice and policy, the decision below upholding viewpoint discrimination under the guise of government speech is dangerous and should be reversed. I welcome the court's questions.
All right, so let me give you a little bit of preview, courtesy of me, of some of the issues that are going on in this case. All right, so the first issue we have to decide is what kind of forum is this? All right, what kind of forum is this? Is this a non-public forum? Is it a limited purpose forum? Or is it a general purpose forum? And has it been a designated forum for any of those things? So there's traditional general forums. Your go-to example is the park. The park is a traditional general forum. Anyone can go to the park and talk about anything. It is open to all speakers on all subjects. It is a traditional, open, general, public forum. Then we have the middle category, the limited purpose public forum. The limited purpose public forum is open to limited subjects, limited purposes. So it might be, for example, a music venue, so only music. Or it might be an art venue in terms of like only paintings. All right, but it's otherwise an open forum for that purpose. So if it was a gallery for fine art that was open, then it would be inappropriate, without more, for someone to come in and want to play music. It's not to say you can't ever have music in a fine art gallery. I'm just trying to make some distinctions here that make sense. Or maybe like a rock band. I don't know. But you get the point, right? But it would allow people to come in consistent for that purpose. And then we have the non-public forum, a place which is not open to general commentary. For example, most government offices are non-public forum. When you go to the DMV, for example, they really would prefer you to stand in line and shut the hell up. And they can make you stand in line and shut the hell up because it is not a designated forum. All right, so those are your three categories. So what kind of forum is this? Is this a non-public forum? Is this a limited public forum? Is this a general forum? And did the government itself change the designation by, appropriate action or legislation? So that's number one. Number two, is this governmental speech alone? If it's governmental speech, we can just kind of stop talking because the government is allowed to speak under whatever terms it wants, just like anyone else. The government has First Amendment rights. So if it's government speech, we can just kind of stop talking, end of analysis. But they've opened it up to other people, at least on some occasions. So it suggests it's not purely government speech. So that's an issue. And then we also have another bugaboo on top of all this. We have the idea of subject matter discrimination or viewpoint discrimination. So even where there's a limited public purpose or a designated purpose, one of the big no-nos is you can't discriminate based on viewpoint. You can't allow some views on a subject but not others. So you can discriminate based on subject in the appropriate forms, like you can say only art galleries, only fine art galleries. But you can't discriminate based on the viewpoint. So you can't only allow art that sends a particular message. Viewpoint discrimination is a massive no-no. So, and also there's another case called Smith, which deals with religious speech in general. And what Smith basically says is that you can't treat religious speech worse or religious regulation worse. You can treat it the same and you can treat it better, but you can't treat it worse. You have to treat it on at least equal ground. So there's a couple concepts that I hope will help understand this case as we're floating around. So you probably will hear these concepts float around. So hopefully with this little bit of preview, you will understand some of the concepts that will be being talked about in the bulk of this case. So in his 2-minute opening, the person who is representing the people who want to fly the flag says we've lost below. We want it overturned. And this is the only time they've said no, and they've said no because of religious reasons and it's viewpoint discrimination. So that's basically his opening. Okay, let's listen to more and see what happens next.
Mr. Staver, you begin your brief by arguing that this is a limited public forum or a designated public forum. And do we have to agree with that in order for you to win?
No, Your Honor. Chief Justice Thomas, this is viewpoint discrimination under any one of the public forum doctrine, even in a non-public forum. If this is it, it's clearly viewpoint discrimination. So this Court does not need to address the category or the kind of public forum at issue. Viewpoint discrimination is impermissible in every category.
Well, that can't be right, because if it's a government forum, and this is government speech, they can certainly discriminate on the basis of viewpoint, right?
That's correct, if it's government speech.
That's correct if it's government speech. If it's government speech, the government wins. We can just stop talking. The government is allowed to have its own viewpoint. If it's government speech, we can just stop the analysis. Okay, great. Let's press on.
But this is not government speech. It's nothing like Walker, which is the outer bounds of the government speech doctrine. It's nothing like summum. The city exercised no control. For 12 years, the city ministerially approved all of these applications with virtually no review.
The policy that they adopted in the middle of this, I guess, saying that they won't fly flags supporting discrimination, prejudice, or religious movements. What if it just said supporting discrimination or prejudice? Could they do that?
I think that would still be viewpoint discrimination. Offense, for example, which that would be what it is in fact viewpoint discrimination, as this Court has already held in
Well,
Mattel.
they can't have
Mattel was a case dealing with offensive names in trademarks. A band called the Slants, which was an Asian band, incidentally, wanted to get a trademark for the name The Slants. The United States Patent and Trademark Office deemed the name The Slants to be offensive and refused to register it. The Asian group went to the U.S. Supreme Court and won. So, yeah, offensive speech was dealt with in Mattel, which is a case dealing with the slants in trademark law. But, hey, law reads from one subject to another.
Official view against discrimination or against prejudice?
They have a view in terms of whether or not the public is allowed to attend a particular event. But this particular policy not only covers the flagpoles, but it also covers the public forums that are out there in front of City Hall, the designated public forums that are clearly admitted. The city could not prohibit discrimination or discriminatory speech within those designated public fora. For 12 years, you had a unified policy.
Mr. Staver, just to follow up on the Chief Justice's question, and this is not this case, but it's an important question because we have to set lines and we're giving instruction to cities about how they can create their own policies. And suppose a city thinks two things. It thinks, we like this idea of having our flagpole be a public forum and having a wide variety of organizations use it to identify themselves and to express messages. So we sort of like this sort of civic organization kind of activity. But at the same time, we think that there are limits. So the city has a policy of that kind, and then somebody comes to it and says, we'd like to put up this swastika on your pole. Does the city really have to say yes at that point?
If it's a designated public forum, I think the answer is yes.
So
but
really what you're saying is that a city can't possibly have a kind of open policy like this, because no city is going to want to put up a swastika or a KKK flag or something like that. So really what you're saying is that this is just a kind of policy that a city can't have.
No, Justice Kagan. In fact, the city could have a more limited policy. It didn't choose to do that. Now, the city's brief tries to indicate certain limitations on categories of subject matters. But that's nowhere to be found in the 12-year or 13-year policy, and it's not in the 2018 codification of that policy anyway. That is not limited to subject matters or speaker identity. If the city wants to open up a forum but limit it to certain kinds of subject matters or speakers, certainly the city is capable of doing so.
So very, very sharp answer to a sharp question, as you would expect nothing less at this level, although as we are well too familiar, many, many times we get less than we deserve at the Supreme Court. But yeah, so Kagan goes to the Nazis, so she Godwins the argument, which, you know, fine. So she Godwins the argument, says, hey, about the Nazis. It's like, yeah, the Nazis too. As well, that means no one could have an open policy because no one's going to allow for that. And he gives the correct response. You could limit it based on subject. You could limit it based on subject. So you could allow it only of flags of particular types. Remember, not viewpoint, but subjects. So there's a lot, so that you could design a policy more narrowly. The city did not do that, particularly because this is a created public forum by the city. So the city could presumably change its mind without too much of a problem. All right, let's go back to the audio. Ooh, picture, nice.
Can the city allow patriotic flags or messages of support and not those that are anti-American? For example, to pick up on Justice Kagan's question, someone wants to fly the Al-Qaeda flag at City Hall in Boston. You're saying they would have a right to do so?
The city, for example, in the Solicitor General's brief goes into that with regards to what the public parks do in the federal public parks in terms of being able to not only use those parks for a wide variety of expressive activities, but for their own specific speech as well. Certainly the city could have a limitation on the subject matters or speakers. For example, the city could limit all the flags to simply flags of other countries, recognizing the various constituencies of their communities. But the city has chosen not to do that.
Sayer, what if the city said, kind of along the lines of what Justice Kagan proposed, said, you know, we want to endorse certain messages. We like this idea of civic expression at the flagpole, but we want to exercise more control. And Boston has said it's going to do that if it loses this case. Couldn't Boston, or I guess I should ask you, do you agree that Boston could accomplish that by making the exact same run of flags that it's had up to this point, government speech, by exercising more control and maybe putting a Boston official next to the flagpole when it's raised up to show that this is the city speaking? Isn't that another way to do it?
Stephanie in chat says that this is straight tactics of propaganda, appeal to the ridiculous. I will disagree in part. I believe that, you know, when you're dealing with issues in law, you have to boundary test. And one of the ways you can boundary test is by extreme examples. And you can ask, does your principle go up to this line? And you can answer either yes or no. And then if the answer is, well, it goes, yes, that's a line. It's like, okay, is the line somewhere before that as well? And why is the line there? Or you have no line. So extreme examples are a reasonable tool in law because you want to figure out, well, where does the principle go and where does the principle stop? What are the limits of this principle, if anywhere? And so the swastika, while an extreme example, is a reasonable example because it's probing at the boundary lines for a potential legal rule. And trying to figure out what, if any, boundary lines can be created and what, if any, boundary lines would make sense based on legal principles. So I thought that was worthy of mention.
Other than just designated as a limited public forum, you know, for these categories or subject matters?
Justice Barrett, that would be a closer call. But in fact, if the city just simply wanted to use government speech as a guise for censorship, as I believe happened in this particular case. That would
I'm not saying this case. I'm saying can't the government choose what it wants to say? And if the government makes it clear and it's not, you know, just stamping government speech on it to hide discrimination against private viewpoints, but if the government truly exercises control, wouldn't that be okay?
If the government truly exercised control, and in fact the brief of the local governments show that Boston is an outlier by many respects. Other cities don't open for third-party flags for obvious reasons. Those that do can invite some third-party participation as long as they maintain very specific control of the subject matters and messages, and that it's very clear that it is their speech.
I have a question about the record. You mentioned in your reply brief this Metro Credit Union flag, but
Yes.
that doesn't appear on the list in the city's brief. And I just wonder, is there some dispute about that?
No, there's no dispute. The list that's in the appendix was the list from 2005 to 2017. The Metro Credit Union is 2018. During that year, there were 50 private third-party applications, and Metro Credit Union was one of those. That didn't celebrate any kind of historic event. It wasn't national. It wasn't constituency or ethnicity related. It was just simply a private credit union that's frankly across the street from where the city hall is. So contrary to what the city says, there's no evidence, they say, that anyone just had a random day. That, in fact, is one of those random days. It's not consistent with the city's now invented categories of national flags and other community recognition.
So what are we supposed to do about that? I mean, you saw, in the brief, what is the brief of various religious groups, one of dark greens. So really look over that 12-year period. We've been getting our sample from 2005 to 2017. There weren't 284 different flags. There were 50 different flags. And moreover, because some ran twice or three times, I guess. And it says, of those 50 different flags, 45%, 90% of them, which means 45, I guess, were like national flags or regional flags. And then of the remaining 5, we had one for Columbus Day, one for Veterans Day, one for Bunker Hill Day, and the other 2 might have been Gay Pride and something like that.
Also apparently Metro Credit Union.
We didn't go through all this control. There wasn't any need to. I mean, sure, those flags are right. That doesn't show they're going to have every conceivable group, including the KKK and so forth. So what do we do about the record in that? Because that isn't really in the record. I don't think what I just read you. Is it? Maybe it is. And then the other question that related that I would have is go to Boston, go look at the City Plaza. I mean, you see 3 flagpoles, and there are flags, and and then they're right in front of the City Hall, and 2 of them, one the state, one the national flag, and this third one. I mean, what are you going to think? Of course, you think it has something to do with the city, something. And so they're saying, look, on the one hand, anybody in his right mind would think it does have something to do with the city. And number 2, there isn't some huge diversity for any group in sight. All there is the flag of Paraguay, and a couple of exceptions for groups that we support.
Justice Breyer, on your last point, taking that first, in the petition appendix on page 142 and then also on 145 to 146, there is a second flag, and that's why they use the word flagpoles. The one that was at issue here was the flagpole near the other 3 in front of City Hall. The second flagpole is part of their public forum as well, and it's on Congress Street, parallel to the city. And in fact, it's the Bunker Hill flag, the picture in the appendix, that's actually raised on that Congress Street flagpole.
That's just the back of the City Hall, isn't it?
The background might be the City Hall, depends upon which way you take the photograph, but it's not in front of the city, and it's not near any other government flags. It stands alone by itself. And as it relates to whether or not certain groups have historically taken advantage of this forum, doesn't mean that the forum is ever limited. In fact, the 2018 policy had the advantage of Mattal, Walker, Sumim, and our litigation, and nevertheless decided not to close or limit the subject matters or speakers.
I guess, though, that one of the points that Justice Breyer was making is if you're on the street in Boston and looking over to City Hall and see these 3 flagpoles, and now you say there's maybe a 4th, but the 3 are sort of together, why would you think that this is anything other than the government flying a flag?
I think when you look at that, Justice Kagan, you're going to see one that's clearly government speech, as Justice Barrett was referring to in terms of limiting. You have the United States flag always up, and underneath it is always the POW MIA flag. It's always there. That's clearly the government speech.
Right, and then there's the Commonwealth flag, and then there's this 3rd flagpole, and you've walked the street many times, and mostly you see in the city of Boston's flag on it, but occasionally you see another flag on it. Why wouldn't you think that this is the city of Boston deciding to put up a substitute flag for its own purposes?
Because an informed observer would understand the history, the policy, and also see the...
Wow, that is very, very informed. I mean, that is not your typical person who walks the street in Boston. And, you know, all they know is I've seen the city of Boston flag here 1,000 times, and now I see another flag. It must be the city of Boston decided to do something else today.
Well, the observer would also see the private event that's coinciding at the same time as the private flag raising, because the private event gathering down there by the base of the flag would happen, as in this case was designed to do. Camp Constitution was going to gather around the base while for 1 hour having an event that would temporarily raise the flag and bring it down. The reason
is it true that one of the flags that has been displayed on this third flagpole is the flag of the People's Republic of China?
Yes, Justice Alito. In fact,
and Cuba was where the Cuban flag was displayed.
Correct.
So, I mean, it might be shocking to somebody walking down the street if they didn't know the background to see some of these national flags flying, wouldn't it?
Certainly. And then if you look, for example, at...
Is that a really certainly? Because there are all the time national flags flying on 16th Street. It just signifies that somebody's come to town. So it's like, you know, the Chinese premier is here.
There's a second reason why it would be that way, because all the time when you had the People's Republic of China by a private organization, the Chinese Progressive Association, flying roughly September, October every year, you always have Mr. Chen, a private individual, protesting that flag by raising the Taiwanese flag, supporting the pre-Mao rather than the post-Mao revolution. So certainly Boston is not one week.
Counsel, I thought, and I may be mistaken, but in one of the briefs they suggested that your client, the petitioner, actually complained to the city about flying the Chinese flag at one point.
That's not in the record, but there was a YouTube video that he took of the raising of the flag, and he put it up on YouTube.
And it was a complaint about the city doing this, correct?
No, not about the city doing it, about the fact that it's the Chinese communist flag. Not the city, because Hal Shurtleff knew that the city...
I think we're missing an essential point, I believe, that I think Justice Kagan and Justice Breyer are discussing, which is to an ordinary observer walking past City Hall, if you see a flag on the pole, you think it's City Hall speaking. You're asking us now to import a fiction that this ordinary speaker is going to also look at the event that's occurring and understand that the flag is related only to the event and not an event sponsored by the city. Is that correct?
Not necessarily. I don't think that the ordinary observer can just be limited to a few seconds or minutes snapshot and discount everything else that's going on before it or that actually is taking place at the same time with the private event taking place. In this case, for example, whether you have the Chinese Progressive Association, People's Republic flag, or the other one, the Taiwanese, the Republic of China flag, I see that I'm...
You can finish your thought.
You're going to have a private event that is happening at the same time. That private event can notify any observer, whether they're familiar or not with the past or the policy, that a private event of a flag raising is taking place.
Thank you, Counsel. I have just one more question. Your friends from the city say that even if judgment should not have been entered in their favor, it shouldn't be entered in your favor either, but the case should be remanded because there are factual issues, particularly concerning whether or not this is a government forum. They say, you know, the mayor was there, sometimes other government officials participated. Do you dispute that?
Yes, Mr. Chief Justice, because this has gone on for a number of years of litigation. There is a stipulated set of facts on page 132 of the petition appendix. There's a stipulation that the flagpoles are included in their designated properties. There's also stipulation as to why they took it down, because of the Christian word on the application, the Christian viewpoint. There is no reason to send this back for a...
So I'm already seeing a masterpiece cake-like decision here, because they are stipulating to the fact that the Christian word in the application. So I'm seeing that this, I don't expect this result, by the way. I don't expect the punt, but I'm just noticing the possibility for the punt because they're teeing it up here with this concession about the Christian word. So the Supreme Court could punt and just go with the masterpiece cake option of you've shown an amnesty religion taking their crack at it. I don't expect that. I expect them to take a firmer stance. It just pop into mind as a possibility.
Additional factors to be developed. The city had all the plenty of opportunity to be able to develop that record, and this is the record that we have.
Thank you, counsel. Justice Thomas, Justice Breyer.
Yeah, I mean, oddly enough, I'm sure this is a useless question. But you would have thought after reading the SG's brief, if they really want to have government speech, it's not too hard for them to arrange it. And they didn't pay too much attention in the past, like zero. And can't it be settled? I mean, you would have thought what's past is past. Let's look to the future. See what Boston wants. You might not disagree. I don't know.
Justice Breyer.
But it just cried out
Justice
with
Breyer
an empty
sounds like
record,
a guy who wants to punt.
Well, Justice Breyer, I don't believe the record is empty. But
no, but I mean, you see where I mean.
Could it be settled?
Yeah.
We thought that this was, in our view, a straightforward case from the very beginning. The city drafted its own policy, and the city used the word public forums. The city said it's open to all applicants. The city acted that way for 12 years, in fact, 13 years, codified the policy, and continued the practice up until October 2021. We thought it was straightforward, but obviously the city, under the guise of government speech condoned by the First Circuit, has ultimately engaged in admitted
that
viewpoint discrimination
sounds so
justified
wrong,
by government
given the
speech.
case law.
Justice
Yeah,
Alito?
I think that's the.
Justice Sotomayor?
I mean, that First Circuit decision sounds wrong. It doesn't sound like that can stand in face of Smith and other cases. So yeah, we gotta whack the First Circuit across the head, man.
Justice Kagan?
If I could just say one small thing, which is I had the same reaction as Justice Breyer had, but you've answered his question. I just want to say now that Mr. Hallward-Driemeier should also think about that question. Why hasn't this case been settled?
Supreme Court doesn't want it, man. They want a punt. No.
All right. That's all I have to say.
Justice Gorsuch? Justice Kavanaugh? Spirit? Thank you, counsel.
Thank you.
Mr. Joshi?
I would expect some very strong decision. I would expect a pretty strong decision for to overrule the First Circuit on the facts of this case. It might be a fairly narrow decision, all things considered. It might be a somewhat fact specific decision, but I would expect. I'd honestly expect even a 9-0 decision on this fact pattern, to be quite honest.
Thank you, Mr. Chief Justice, and may it please the Court. Like any private property owner, the government is entitled to use its own property for whatever lawful purpose it likes, including for expressive purposes. And when the government expresses its own viewpoint, it is never compelled to express competing or alternative viewpoints. Government could not function were that the rule. And, of course, when the government expresses its own viewpoint, it is free to solicit input from and assistance from and even other messages from third parties in helping the government to shape its own message. But this Court has said that unlike a private property owner or a private speaker, when the government chooses to open up its own property for use by third parties to express their messages, the government cannot restrict access based on viewpoint, including religious viewpoints. Now, I admit, and this Court has recognized, that it can be a really fine line between the government's soliciting messages from third parties to help shape its own message on the one hand and serving as a conduit for the third parties to express their own messages on the other. But the record in this case, viewed in the light most favorable to the petitioners here, suggests that what Boston did, at least at the time of the denial of petitioner's application, was the latter and not the former.
Counsel, what's at stake in that line between public forums and government speech? On the one hand, you emphasize the government's right and entitlement to edit speech of its own. But what happens when that doctrine goes too far? Why does the government think that this properly belongs on the other side of the line?
So, as I said, I think ultimately the question is always going to be who is speaking. And as this court told us in Mittal against Tam, the fear is that the government could simply, by putting its stamp of approval, as Justice Barrett mentioned in her questioning, on private speech, it could favor certain speakers over others, and the First Amendment tells us that that's off limits to the government. But that said, I think in this particular case, as in all cases, the question is going to be highly fact-bound, and it's going to depend on really the answer to the question, who is speaking. In this case, every time one of those 284 flags went up the flagpole, was that Boston speaking each of those times, or was it the third party whose flag it was?
Why does the government come down on that side of the line, though? What are the factors you think that we should be using to guide us in drawing that very difficult line between these two doctrines?
I think ultimately the factor is the ultimate question is, what did Boston do when it created the flag-raising program? And here I think there are a number of facts in the record that would tip the scales toward believing that Boston created a forum, even if it's a non-public forum. The 284 approvals in a row, of course. The fact that Rooney would approve these in an almost ministerial manner without ever looking at the flags, without requiring that the actual flag design be shown, is underscored by the fact that petitioner's flag apparently would have passed muster but for its description as a Christian flag in the accompanying email. The fact that flags raised in the flag-raising ceremony were, generally speaking, at the request of a third party and not initiated by the city itself.
So, Mr. Joshi, suppose you're right as to all of those things, that there was essentially no control from the city government here, and that pushes strongly in the direction of, well, it's not government speech if government doesn't control it. But suppose, on the other hand, one thinks that reasonable observers would think that this was government speech. And there might be some arguments about that, but I just want to assume it for the moment. Suppose one goes in one direction and the other goes in the other direction. How do we think about that?
Well, I think first, a reasonable observer ought to be charged with knowledge of the basic contours of the program we're talking about. This Court's cases dealing with forums, going back to Widmar and Rosenberger and Lamb's Chapel, some of the others, Cornelius, have said that the right unit of analysis is the program to which the plaintiff seeks access. It can't be at too high a level of generality, so it's the combined federal campaign, not the federal workforce. In Lamb's Chapel, it's use of the schoolrooms after school, not during the school day. And so I think here you would have to assume that the reasonable observer is aware that there is such a thing as a flag-raising program.
Yeah, I mean, Justice Sotomayor called that a fiction. And I think that's an assumption that does verge on a fiction, right? The person walking by City Hall every day does not know about the contours of the flag-raising program. It just knows on Monday through Thursday I saw the City of Boston flag, and now I see another flag. Surely that's just the City of Boston deciding to fly another flag instead of its own flag.
So I have two related responses to it. First, I think it's just as likely that an observer might know that there exists some kind of flag-raising program, and when they call into Boston to complain about the flag they see on the flagpole, they're not necessarily complaining that Boston is endorsing that flag, but rather they might be complaining that Boston has opened up its flagpole for a use that would permit such a flag to be flown. But more broadly speaking, I think it would be a little bit problematic if we allowed, and I realize I'm speaking on behalf of the United States here, but we take this Court's cases to say that the First Amendment should not allow a government to evade the strictures of the First Amendment and the prohibition on viewpoint discrimination simply by being innovative in its program, or by fooling the public, or by having a secret program on the side that only a few people know about. The fact is, once the government, or the City of Boston here in particular, is chosen to open up its flagpole for use by third parties, the First Amendment imposes certain restrictions on how it can run that program.
You listed certain factors, I think 3, the 284 approvals, they were approved in a ministerial fashion, the flags were flown at the request of a third party. Were there more you were going to say there?
Yes, Justice Kavanaugh. Another one is that these flag raisings were generally accompanied by a flag raising ceremony at the base, and often by an associated event in City Hall. This court in Christian Consciousness, one of the several Christian Consciousness cases, mentioned that separation from a traditional public forum could help make you think that it's government speech as opposed to a forum itself. It's the same application form that people use, and I think this is a Pet App 148. Boston says that they process applications the same. If you go to the website today that lists the new 2018 policy, it directs you to exactly the same application you would fill out if you wanted to host an event on a concededly designated public forum. And, of course, Boston's own desires for the program itself, which is celebrate diversity and foster connections among Boston's many communities. They didn't.
That makes the doctrine, though, seem quite circular in the sense that it is a public forum because of what they've done, and it'll be easy, presumably. And why don't you tell me what you think Boston would need to do to change this from a public forum to something that's not a public forum where they could permissibly exercise control?
Yes. So I do think, to directly answer your question, it should be rather easy for the government to change things. This court expressly recognized that in Perry, and in a line of cases.
And what specifically do you think they'd need to do?
As we suggest in the back of our brief, they could do a couple of things. Obviously, government property can be used both for government speech and to create a forum, even if it's a limited or a non-public forum. And so Boston could take a two-track approach like that. Most of the time, it does use the flagpole for its own flags. But if it wanted to preserve this kind of flag-raising program in which third parties could raise their flags, they could limit it, as we suggest, and as Mr. Staver pointed out, to flags of countries.
Could it limit it only with the purpose of discriminating against religious viewpoints?
I don't believe that would be appropriate. This court has said that even in a non-public forum, viewpoint discrimination is impermissible, and we read Rosenberger, Lamb's Chapel, and Good News Club to suggest that prohibiting all religious viewpoints is nonetheless viewpoint-based discrimination, so I don't think that would be an available tool.
Mr. Joshi, I want to follow up on Justice Kagan's questions about what an informed observer might think about seeing this flag, because I agree with her. This really is a fiction, and this goes to Justice Souter's concurrence in some. I'm trying to figure out how much the observer or the informed observer knows. It seems to me that when you think about the three factors from our case law, control does almost all of the work, because really it's the informed observer knowing about the degree of control that the government exercises that, if we're creating this fiction, makes the informed observer think or not think that the speech is actually uttered on behalf of the government. Would you agree that control is the most important factor?
I think that's right. Control is the most important factor, and that's because all of the factors in Summum and Walker are just that. They're factors to determine who is speaking, and when you're asking the question who is speaking, generally the person speaking has exercised some degree of control over the message that's being conveyed.
Well, what if the city exercised complete control in this sense? It has a policy that says anybody can put up whatever message they like on a big billboard that we have in front of City Hall, except that we will review all of these messages and we will exercise complete discretion in deciding whether we will allow the message to be put up. And in exercising that discretion, the city disallows any message with which it disagrees. Now, there's complete control. Do you think that's government speech?
That's sort of difficult to answer, and I'll just give you a couple of the things that
How can it possibly be difficult to answer? Suppose that it was the speaker's platform in a park, and they say, anybody can speak here, but you have to give us your speech in advance, and we're going to exercise complete control over what you say. If we don't like your speech at all, we're going to reject it. If it's got some things we don't like, we're going to edit it. Other than that, you can say anything you want, subject to our complete control. That's government speech?
That's obviously not government speech and obviously forbidden. And in particular, you said a public park where that is.
Well, let's say it's in front of City Hall. It's not a public park. It's on public land in front of City Hall. My point is control can't be the be-all and end-all because censorship involves control. Censorship, that's exactly what censorship is.
Nice question. And it goes to pose the challenges here to which the answers are not obvious. It makes you think, which is why this stuff is good. Because one of the things we're trying to divide, I suppose is better. Trying to divide is the difference between government speech, when the government can speak as its own speaker, and speech that the government allows to be spoken, which is not the government speech. Right? So if you have your traditional, if you have your public forum, whether that's designated or traditional, we'll make it designated, make it a little bit interesting. That's why Justice Alito screwed up, and he recognized he did when he mentioned park, because park is a traditional public forum. He said, okay, screw that. How about the steps of City Hall, which is not, right? And he says, okay, so the government says it wants to give a speech on City Hall. Okay, that's government speech, right? Say, well, where's the dividing line? And one of these criteria is control. And it says, well, how much control? It says, well, what if they make every speech be approved by them? So they have total control. Is that government speech? And the answer might be yes, to be honest. But Alito actually points out that if the answer is yes, then censorship is nothing but control. So the easiest way for the government to potentially, well, I don't know if it's the easiest, but it's a path. It's a suggestion, at least. A potential path for the government to get more control is to exercise more control. Control is its own justification. So if they say, okay, yeah, you can say anything you want, but we have to approve it first, is it government speech? Is it something else? Good question. Good boundary testing question, an answer to which is not immediately obvious to my mind. Good stuff, man.
You're absolutely right. I'm not going to fight you on that, but I guess what I'm saying is that one can imagine the city, if it chooses to, say, on its website, host articles about Boston and how great Boston is. They might not want to write all of them. They might say, submit your essays, but this is on our website, and it's going to be from our viewpoint, and if we agree with your viewpoint of why Boston is great, we'll publish your article that you've submitted to us on our website. I think that looks a lot more like soliciting third-party views to shape a government message, and so to the extent the billboard example would be similar, that very well might be government speech. But I think in most cases, if what the city is doing or if what the governmental body is doing is simply inviting a diversity of viewpoints, then it's no longer government speech, and then it really does look like putting a stamp of approval. I guess an analogy I would give you.
So I like this answer, although it's not completely satisfying to the problem. But it's a reasonable answer, although I'm not sure it's a complete answer. And that's not meant as a chide. It's meant as just a note, because I can't think of a complete answer either. So if you have a government TV channel, if you have a government billboard, it's government speech. If you're really just soliciting diversity of viewpoints and then giving approval or not, then that looks more like government facilitating than government speech. So where do you draw the line? And the line gets a little bit blurry between the two, which was sort of the premise we walked into this with, if you remember earlier in the oral argument. So like on the one hand, we have government speech where the government has total control. On the other hand, we have speech that is, let me try this, and let me try the dichotomy again, because the dichotomy didn't really quite work. On the one hand, we have the government soliciting from third parties ideas for speech, but it's really its own speech. So the government is asking third parties, whether it's limited or the public at large, it's asking for ideas that will in fact be its own speech. So it's soliciting suggestions for its own speech. That's on the one hand. On the other hand, we have the government giving a forum for someone else's speech. And how do you tell the difference between the two? How do you tell the difference between, on the one hand, this is the government speech, and we're merely consulting people, even a lot of people, even the public at large, to figure out what our speech should be. But on the other hand, this isn't really our speech. This is really other people's speech, but we're exerting total control over it. But it's really other people's speech. You see, these two things can look kind of similar. So there's somewhere like between these two concepts that's a little bit uncomfortable. And this question and this answer is going to this aspect. It's like we kind of believe that both these answers are right, but when you push both boundaries to the breaking point, then both concepts kind of explode. But we think both premises are right. So it's one of those areas, and what makes it so much fun for me as a person who loves this content, loves to think about stuff, what makes it so much fun is that you have these two concepts, and you think both of these concepts are correct. And then you try to maximize both concepts, which goes to like Kant's idea of the categorical imperative. So you try to take both concepts and maximize them, and you run into friction between them. And so you're faced with tension, if not contradiction. So how do you resolve the problem? And so one of the things you could do is you could say, well, we can blow apart one or the other, or we could try to find some resolution, right? But I at least haven't found the answer yet, and neither are they. So we're, at the moment, our answer is we're just living with the tension. We don't have the answer yet. You know, on the one hand, you have speech that is absolutely the government speech, where they're soliciting third parties, either selectively or in large, or the public at large, but it's definitely the government speech. So that's one category. On the other category, we have, it's really a private person speech, but the government is creating the forum for the person to speak. But if it's really the private person speech, but the government is creating the forum for it, their mere fact that they can control the forum and exercise totality over the forum is not sufficient to transform it into government speech. So even though they have total control, authoritarian control is not sufficient to transform it into government speech. And how do you tell the difference? It's a great question. Really makes you think. It's fantastic. This is one of the reasons I love Supreme Court React, because every once in a while you get a question, you're like, oh, that's really, really good. I don't know the answer. I'm not sure there is an answer. $25 from Stephen Oldsby. If your speech is either canceled or totally edited, then you're just a mouthpiece for the government and they're delivering the message. Yeah, but the question is, whose message is it? Yeah, the government might be delivering the message, but whose message is it? Right? That's more the problem. It's a great question. It's good stuff, Shit. It's good, man. Let's press on.
Is the difference between, say, hosting a symposium in which you're sort of curating who's going to speak. You might be inviting a diversity of views, but within a narrow band, and you're exercising a lot of control, versus hosting an open mic night, where you have the mic available, you're serving as a conduit, and third parties can come up and give their views. And I think that's the key question in this case. Was Boston hosting a symposium of flags in its communities, or was it more like an open mic night?
Well, if that's the key question, then how do we answer it? Because I don't find any. Look, I look at the record. You saw it, 173, 180 something, and hey, it says Lithuania, Dominica, Tibet, Ireland, United Nations, Vietnamese, Poland, Haiti. As I look through that, it's certainly 90% national flags. And then they have a few others. Okay, so and then that isn't even in the record. I don't think any of this stuff. I think this is somebody printed it or something. And so, what am I supposed to do? What I'd like to do is say, send it back and find out what they actually did. But that doesn't seem necessarily possible. I don't know. That's what I'm asking you. I really don't know. So, what do I do?
I'll answer those in turn. First,
Yeah.
I do think that list of flag raisings is in the record, and the 2018 that included the Metro Credit Union, that's also in the record.
Yeah, we have one Metro Credit Union, and you have 99 their favorite countries. I don't know if China's their favorite country up there or not, but nonetheless, they have countries and regions.
Yeah,
90%. So what? We say 90%, there you have 10% that's other things, and therefore you're not government speech. But if it or the opposite, at 73%, that would have made a difference. Is that the kind of holding you want?
I don't think that would be appropriate or even relevant, Justice Breyer. I think the point is that even if you accept that, although it doesn't exactly match their past practice and they haven't codified it, but even if you accept that what the city wanted to fly were flags of countries and flags commemorating holidays, that doesn't necessarily mean it's government speech. It could still be a non-public forum in which it invites Boston's communities to raise the flags of their countries of origin. It could.
We now need to take a break to enter into the stream. Legal Bites.
Who doesn't know how to do math?
Legal Bites, I'm so sorry about any miscommunication on my part.
No, I don't think that was your fault. I think because we were talking about, you were talking about Central Time. And I was doing my math entirely wrong.
That's okay. Math and lawyers, right?
I know. This is why I became why we all became lawyers, right? Or at least one of the reasons. I very much apologize. I know I've probably missed a lot at this point.
No, well, and you just missed a really great, what I thought was a really, really great philosophical point of tension between these two sides.
Okay.
That makes you think about the deepest levels of the issue.
Okay.
Because it seems like both these principles are correct, and there's a collision point.
Okay.
So, on the one hand, we have what we'll designate is actually purely government speech. So it is the government who is the speaker. There doesn't seem to be any problem if the government is in fact the speaker, with the government soliciting other people's views as to their own speech. So if the government is interested in speaking, they might, for example, consult other people, including potentially a large group of people, including potentially the public at large. They might solicit opinion from a large group of people, or select people, or whatever. It's their decision. But whatever happens at the end of the day, it's the government speech. So they'll take it, they'll do whatever the hell they want with it, select various viewpoints that please them, diminish other viewpoints that displease them, and at the end of the day, it's the government speech. So that's on the one hand. On the other hand, we have the idea of the government opening up a forum.
Mm-hmm.
So it is a government, we'll say a designated forum to make it slightly easier. So it's a non-traditional forum. It's a government designated forum. And the question is control enough? Because one of the hallmarks of the idea is control. And so I think it was Justice Alito was pushing this boundary. It's like, is control enough? Because let's go to the extreme end of the page. The government designates a non-traditional forum. It's a general forum or a limited purpose forum. Doesn't really matter for our purposes. And they say you can give any speech you want, but we get to review it first. You have to submit it to us first. We get to review it first. If we like it, fine. If not, we can edit it any way we want. We can change it any way we want. We have total control. We can stop your speech, but you can give any speech you want. Right? And so Alito asks, is that permissible? And so the answer seems like no. And so the question is, how do you tell the difference between the two? And to me, there's no obvious answer. How do you tell the difference between the two? Which makes the question interesting. It's like, how do you tell the difference between a government, what is purely government speech, in which we can solicit other viewpoints, but it's really government speech, versus it's really not government speech, but the government has total control over it.
Yeah.
And so the two factors are kind of the same. It's just you're just kind of changing the order you're presenting them in, right? It's The government's it's really the government's speech, but it's other people participating. But it's really the other people's speech, but it's the government's control. And so
it seems like
there's tension point.
It can look like it's a government endorsement of a particular viewpoint.
Yeah.
Oof.
But but
such an interesting case.
Yeah, the thing is too, because like, if you concede the government limited forum. So it's a government limited forum. Anyone can speak, but we get to review your speech and we get to edit your speech before you can give it. So if you concede that ground, then the question becomes, okay, how much less control? So the government says, okay, we're not going to exert that level of control. We're going to taper it down. So then the question becomes, at what level of taper? Right?
Yeah.
Is it now no longer the government has sufficient control, and it's really now the public speech again, which is a problem, because if you answer that question, you're incentivizing the government to exercise maximum control. So if you say, well, if you say all speech is okay as long as we approve it, if you say that's okay but some lesser version is not okay, what's the incentive for the government?
Yeah.
To censor the shit out of everything.
Right.
And censorship is control.
Right. That's
so
going to have a chilling effect, so to speak.
It's a fascinating question from a philosophical frame to me. And I don't know. I apologize if I'm not explaining it well enough. I'll take full responsibility because I know you're coming into this cold. But I found it to be a fascinating exchange.
Yeah. No, I think that this sort of fits into what I was thinking going into this question, having read just a little bit of the background and what led to them coming up to the Supreme Court. I mean, it's such a fascinating situation. And so just a question for clarification. This is there's no part of this that's talking about either of the religious First Amendment clauses, are they? The establishment or the
It didn't particularly hurt that when they eventually codified this, which I don't think happened until relatively recently, but when they eventually did codify it, they said we're not going to allow offensive speech, and then they basically said and religious speech, and kind of mentioned it in the same exact breath.
Okay.
Didn't exactly help. And
okay.
It also doesn't help, as you may remember, there's the famous case Smith, which deals with religious regulation, which basically says in so many words that religions can't be treated worse than comparable speech.
Right.
Well, comparable speech
comparable
is
secular.
Than comparable secular activity.
Yeah.
It is Smith. So there's that too. And it
So have they touched on those points yet during the oral argument, or has that come up in any of the briefing? I haven't looked at any of the.
Well, I haven't looked at any of the briefing. I'm coming into the Supreme Court argument fairly cold.
Okay.
But there was this one, because I had a pretty strong opinion on it coming in, but I was very, very pleased for myself at this question from Alito and this exchange where I'm like, there's a tension point here that I can't quite resolve, and I don't want to give up on either of the principles. Right. So one of the solutions is you give up on the principles. It's like, well, I don't really want to give up on either principles, and so it's like I have a very uncomfortable tension point where I don't quite know the answer in the middle ground, and that's fun for me.
It is fun. It is very fun. I mean, anytime you have an intersection of these very important rights, I mean that's some of the most interesting aspects of any kind of law, but I mean especially constitutional law. So that's what really attracted me to this case.
Yeah, it's this great thing. It's like, well, these both must be true, but they can't both be true, but they must both be true. And it's just like this fight. It's like, and it like I don't know. I kind of like that feeling of almost my intelligence being on fire, where it's like I just feel like that feeling of that tension where it's like I have to have this intellectual fight. It makes me feel like I'm alive, man. It's great.
Yeah.
But maybe that's just me.
No, I love it too. So okay, well, cool. Thank you for kind of bringing me up to speed with the
So apparently the history from 2005 till 2000 I'm going to get these dates wrong. 2017 was mostly country flags with some Columbus flags and some other major, holidays. Apparently 2018, the credit union across the street got a flag flown for just randomly.
All right.
So,
all right.
but
still be a non-public forum in which third parties are invited to come and celebrate holidays. And if that's what they were doing, then they would have to be viewpoint neutral. So country flags, they'd have to fly the Vatican. Celebratory day flags, they'd have to fly a Columbus Day flag.
Thank you, counsel. One question.
I do like the inherent implication that flying the Columbus Day flag would be offensive.
Yeah, well, but it also could be considered a religious flag too, because there is, the Catholic Knights of Columbus. That's a thing. That's the Italian community still, celebrates Columbus Day, or that's kind of why it was created in the first place.
That's a lot.
What about the issue that your friends on the other side say there is really still open? They say that the record will show, when it's developed, that the mayor came to a lot of these things, or some other governmental representative, said that they're often in connection with governmental proclamations, the people of Italy or whatever and all that, and it's the Italian flag. Does that change your analysis about whether it's government speech or not? In other words, it's in conjunction with other governmental activities.
Had that been in the record, it may well have, because that would suggest a degree of governmental control, involvement, perhaps initiation. But in this particular case, first of all, I don't think that's in the current record on summary judgment. And I'm an appellate lawyer, not a trial lawyer, but my understanding is you usually can't reopen these things. But second, I will say that the city itself seems to understand the difference between when it wants to speak on the flagpole and when third parties speak pursuant to the flag-raising program, and I'll just give you a couple of examples. The district judge mentioned a couple of times that the city had raised a pink transgender flag. That's not in the list of flags in the petition appendix
on our sleeve. Let me know the truth.
Lawson provided to petitioners during the litigation.
Do you know that one legal bites?
173A. Likewise, this is not in the record, but it's common knowledge that I think in 2014, then Mayor Walsh raised the flag of the Montreal Canadiens, a hockey team that I think had just defeated the Boston Bruins in a playoff series. That flag
I can understand why it wasn't put in the record.
But that flag's not in the list of flags either. And I think that just shows that respondents understand when they're using their flagpole to speak.
I feel like at this point, if no other, now's as appropriate time as any. I would do anything for love, but I won't do that. No, I won't do that.
That was beautiful.
Thank you.
And when flags are being raised pursuant to this program.
Justice Thomas? Justice Breyer? Justice Alito? Justice Sotomayor?
Yes, counsel, in your response to the question of deciding whether control is the only factor, I think your answer to Justice Alito has to be no, because in your response you started to focus in on forum a lot, because your response was in a park they couldn't do the kind of content or viewpoint discrimination that they might be able to do at the flagpole. Am I right about that?
It's correct that a park is a traditional public forum.
Is that answer just like the most condescending answer possible in this context?
Question?
Yeah. It just feels like the most lost lady answer possible, that the park is traditional public forum. That just feels like, let me insult the hell out of you. Is it just me?
Yeah, it definitely felt like she had an underlying reason for it.
Yeah.
So the nature of the forum is important. So do you agree with with petitioner that forum is irrelevant in this case? And if you do, why is it irrelevant in this case?
I don't think it's irrelevant, but I do think that you have to look at the program that Boston created. So it's not flags in general, although that is relevant, but I think you have to look at the particular program that the city created, which is a flag-raising program in which it seemed to, from its actions, invite a diversity of views.
Thank you, counsel.
Yeah,
Justice
practices
Kagan?
are a good way to tell the
So,
difference.
Mr. Joshi, I don't want to put words in your mouth, but if it's a program that is attempting to invite a diversity of views that believes in civic speech, civic organizations, essentially you're saying once you have that kind of program, the city loses all control over it. Even if the city wished to maintain control at kind of the outer edges of the program. And again, I don't want to talk about the facts of this case. I want to talk about sort of other cases. Like, a city couldn't do that and keep out the KKK flag.
I disagree. I think it could. And I think to a certain degree, this case, at least below, was litigated as a binary choice between government speech on the one hand and a designated public forum on the other. But I think that ignores the fact that this Court has recognized there are limited forums or non-public forums in which content-based and even speaker-based restrictions on the use of governmental property for communicative purposes are acceptable as long as they're reasonably related to the purpose of the forum. And so that's why in our brief we suggest that the city could still have this program while excluding things like the KKK flag. If the program is reserved for flags of countries from which Boston's community members originate or have, ancestors.
I don't know.
Right.
They wouldn't have to
I guess
fly
I was suggesting that that's a much more limited program than the one that I was positing, which is a program that's meant to say, we want to hear from all different members of our community on the things that they care about. Not just like which country they're from. So they can put up whatever flags they want to, but we're going to draw some lines. Essentially, you're saying they can't do that.
I'm saying they can draw the lines based on content and based on even speaker status or identity. So, for example, nonprofits only, or I think, Justice Kavanaugh, you mentioned Al-Qaeda. No terrorist rule seems pretty reasonable to me, so that would probably pass muster. But they can't draw lines based on viewpoint. So if the program is such that, for example, a group could raise a Black Lives Matter flag, they probably would have to be able to raise a Proud Boys flag. I mean, that's just what the First Amendment demands, even in a non-public forum.
I also like this answer because of the cities that have put Black Lives Matters on the street. Mm-hmm. And there was a city coming out of, did it come out of D.C., in the Court of Appeals of D.C., or did it come out somewhere else that I really disagreed with, which said it was still governmental speech, but I didn't buy that. No, it was New York. It was New York. I remember now. What said it was really governmental speech with the Black Lives Matter. I was like, I didn't buy that for 1 second.
Yeah. Yeah. No, I mean, and various governmental buildings and whatnot have featured not just Black Lives Matter, but also the Pride flag and things like that that have been viewed as more of a political viewpoint kind of thing. So it's yeah.
Well,
fun times.
Maybe with the possible exception of the credit union flag. I think flags are kind of political by their nature, but
well, also, I mean, the sports flags and whatnot too. That would also probably not be political, unless the particular clubhouse has taken a political stance at some point, and then it becomes political. But inherently, I wouldn't say that they would be.
Justice Gorsuch, Justice Kavanaugh, Justice Barrett.
I just want to return to this control question in the colloquy that you had with Justice Alito. So the factors from our case law are the history, the way an informed observer would perceive it, and the control. And it doesn't seem to me that either history or how an informed observer would perceive it necessarily suss out this question of whether the government is using it as a cover. So you said in figuring out if the government is using this as a cover for censorship, we would be asking, is this more like a symposium, where a diversity of views on a particular topic are solicited and welcome? Is that a subset of the control factor? I mean, none of our cases that I can think of are really getting at that question of sussing out government just trying to put a stamp of approval on speech to weed out certain disfavored speeches, at least not Summa Walker and what was the other one? The
TAM.
License plate, TAM. Oh, yeah, the trademark. So how do you suss it out?
I think it's ultimately going to be really fact-bound. I guess I would point the court to Forbes, the Arkansas Educational Television Commission against Forbes. There, the court made clear that a public broadcaster who's exercising editorial control, a sort of curation of what program.
Was that the New York case? New York public access, I think. Arkansas educational, because there was a public access case. Didn't it come out in New York dealing with public access television, whether that was governmental speech or not?
I'm a little
like 2 terms ago.
I'm a little foggy on those details. I'm not sure, but it sounds vaguely familiar.
Somewhat into a bottle of bourbon, so yeah.
Programs to air, that's government speech, and the court said that expressly. Even though the programs are created by third parties, the editorial control was government speech, but a candidate debate in particular was a non-public forum in which viewpoint discrimination was prohibited. And that's the kind of analysis, unfortunately, it is fact-bound, that has to be brought to bear in every case. But again, you have to look at the particular program. Imagine Summum, for example. Those 3 factors that you discussed were discussed in Summum and pointed toward government speech. But imagine if the city of Pleasant Grove also simultaneously reserved a corner of that same park for a Monument of the Week program. I think the court might have had in which all comers could come and put their monument up for a week as long as it satisfied certain size criteria, and then took it down and it was returned to them. I think the court might have had a different reaction to whether that piece of it was government speech, and that would be sort of regardless of whether a passerby would know that that corner was for the Monument of the Week or was for the permanent display.
So returning to Justice Kagan's hypothetical about how such a program might be structured, would Justice Kagan's envisioned program work if, to celebrate, all of the commitments and ideals of various civic organizations, the city of Boston sits down, asks what's going to be expressed, and says, yes, this is an idea that Boston can get behind, and a government official participates in the flag raising, participates in the ceremony, communicating that, yes, Boston is happy to celebrate and communicate Pride in Juneteenth, but no, Boston is not going to participate in a flag raising for the Proud Boys. Is that a way to structure Justice Kagan's program?
Absolutely. I think that would be government speech with that level of control, that level of planning, and that initiation. I think that would be government speech.
I want to go back to this question, see if it splices that for me. Returning to Justice Kagan's hypothetical about how such a program might be structured. Would Justice Kagan's envisioned program work if, to celebrate the commitments and ideals of various civic organizations, the city of Boston sits down, asks what's going to be expressed, and says, yes, this is an idea Boston can get behind. A government official participates in the flag raising, participates in the ceremony. He says absolutely. I have to tell you, I'm not sure, ma'am. I'm not sure that's what makes it such a great question.
But I don't know if he's saying that would be a proper way, because he says that would be government speech.
Would it though?
I mean, I think that level of control probably would be. I do agree with that statement.
I think you're back to the fundamental problem though. If you're pinning it back on the level of control as your I mean, I'm thinking through the issue too, so yeah. I want you to understand that I'm not trying to give you a hard time.
Oh yeah,
for the sake of it. I'm trying to work through it myself.
Yeah.
Because if you go back to the idea of the level of control being the factor, is it the only factor? Because if we're back to that, then it's just an issue of the government has to censor enough, and you're there. Is that what we're saying? If the government censors enough, you're there. Then it becomes governmental speech. If you don't know the answer, if you want to criticize my premise or you want to attack me, that's fine. I don't care.
Yeah, no,
make me think. Legal bites.
This seems like what they're trying to figure out too. So I mean, it seems like I would think that it would be an appropriate question to ask, or at least to have that would be a relevant factor to look at the level of control by the government in the particular, because I mean you think about the cases about licensing for demonstrations in a city. where a city is doing exactly this level of evaluation, saying like, well, what are you going to talk about? Well, okay, this is a group that's
but do they though? I don't know for sure, but I don't know for sure. But typically in those, I think they just evaluate for
inappropriate. Is my point, is that where a city government has said, well, no, you guys are going to have a protest about XYZ, and this is who you are, and therefore that means that we're going to have to hire more police, we're going to have to do all of this to maintain security, so no, you can't do this, we're going to deny your license. And
see,
the
but
court has
that's
said
exactly, I mean, for my money, we just go back to Stokey and we call up our friends the KKK, and where the ACLU actually cared about the First Amendment. Fuck the ACLU these days, but the ACLU defended the KKK when they wanted to march in Stokey, Illinois, because of exactly this. It's like, they want to have a march. The goddamn Klan want to have a march in Stokey, Illinois, and the ACLU defended the Klan because freedom of speech matters. And I have no particular objection to the government wanting to require permits because they need to make sure they have enough staff or whatever. But for them to impose, I'm pretty sure there's Supreme Court guidance on this issue about imposing fees because of excess security and stuff. It just becomes a tax. It's like you can impose the processing fees and some standard fees, and that's about it. If it costs you more to hire more police, then sucks to be you, government. That's the collective expense we've all agreed to pay by the First Amendment, by allowing that speech to be expressed. I continue to defend to this day the rally in Charlottesville. I do not defend the people who committed crimes in Charlottesville, including the person who runs someone over with a car who deserves to go to jail forever and ever and ever.
Right.
But I absolutely defend, people with their fucking goddamn teaching torches, which is the bullshitest, stupidest goddamn messaging I've ever seen in my life, specifically so I can say that. I believe in freedom of speech for everyone. I believe in speech that I find reprehensible.
Right.
Jews will replace us is reprehensible speech. But the fact that we protect that, the fact that we protect the KKK and Stokey, is what gives me the ability to say things that are significantly less controversial, I would hope. But in these days of political correctness, who knows?
Who knows?
Even more controversial, Fauci may not know everything.
Oh no. But my overall point though was
was it the Nazis versus Stokey? Maybe it wasn't, because it was Nazi. Someone said in Super Chat, was the Nazis versus Stokey? Maybe it wasn't Nazis. Maybe it wasn't the KKK. Maybe it was Nazis. Yeah. Either way, didn't impact the analysis that much. But
typically
KKK, Nazis, half a dozen, 1/6 the other, blah blah blah.
In a lot of these kinds of cases, because those are the ones that tend to really illustrate where that line is for us, right? Because it's like you're usually not going to have a very strong lawsuit over
do you defend
Girl Scouts or something like that.
Do you defend the Nazis, Alita?
Not their actual points of argument, but I do defend their right to protest and to gather and to speak. So I definitely don't endorse any of their positions by any means. So to make that very, very clear. But my point in bringing up that comparison is that the Supreme Court has basically, in those kinds of cases, said the government can't take that kind of a detailed analysis in determining whether to allow or not allow this group to gather and to petition and to have a rally. And so it seems like it seems kind of similar in this situation, even though we're not talking about the government wanting to determine security issues and that kind of stuff. We're still talking about the government saying, okay, well, we want to really analyze what exactly is the thing that you want to be saying in this space that we are allowing people to come in and express different views.
Yeah, and I again, that goes to the tension point, because it's like, should the government be allowed to make the decision to open up a point based on what views may or may not be expressed there? There's some great First Amendment tension points, which are very, very interesting and make you really think about the full implications.
Yeah.
I feel like nuance is a problem, and I feel like really thinking through all the issues is a problem, because and it could be wrong. Maybe I'm overthinking issues. Maybe I'm not seeing things. But for me, I'm trying to run everything to the end of the page, and running into problems is because I want to have a consistent philosophy. And
yeah.
Maybe it's simpler than I'm making out to be, but it's when you try to really push these things to the limit, that's where the fun really begins.
Of course. Anytime you have this, like I said, this intersection between these different concepts and between these different policies, it's the most fascinating, because you really start to understand exactly where the lines are drawn. So,
as I've said this before and said again, one of the things I'm very grateful for the entirety of LawTube is that I have other people who I can talk to who make me think.
Yeah, absolutely. I completely agree. I feel like I've learned so much just by being a participant of LawTube.
Yeah.
So the difference is the government involvement. Like, it would be difficult to set up the parameters for, say, a limited public forum, as Justice Kagan was proposing. But if the government gets so involved in it that it's standing outside endorsing that speech, then it would be government speech.
I think that's right. The difference between a symposium and an open mic night.
Thank you, counsel.
Good landing line. I'm not sure how far it goes, but we'll give him credit for the line at least.
Mr. Hallward-Driemeier.
Mr. Chief Justice, and may it please the Court, the sole issue here is whether the city's decision to lower Boston's flag from the City Hall flagpole and raise another in its place is the city's own speech. If so, then, as summum held, the city is free to select the views it wants to express. If, however, the flag raisings were private speech and the flagpole had become a public forum, then the city agrees that it cannot exclude petitioner's flag. Thus, whether the flag raisings were government or private speech is dispositive. The facts here are at least as supportive of the city as in summum.
Now, in some ways, I kind of appreciate the framing. I'm surprised by the framing, to be honest.
Yeah.
Because I hadn't heard this before, but I appreciate the framing.
Yeah.
In some ways it simplifies the issues radically. If it's government speech, we win. If not, we lose. It doesn't come a lot simpler than that, right?
Yeah.
What do you think about that as a strategy? I don't know if we're in a position to critique, because these people have had forever to think about it, but man.
Yeah,
that's a position.
It is. It definitely is. It's pretty illustrative of this idea that, where basically what they're saying is, hey, we're just filling a gap here that has been created. That's basically nothing different from, let's say this. We have a government office that is typically occupied by a government worker, and we open that up sometimes to some people, but it's still a government office. So we still have the ability to close the door and open the door whenever we want and for whomever we want, and that's up to us entirely. So it's a very illustrative way of putting that point out there. So I do agree. I think the framing is very is a very interesting strategy. I kind of like it.
I think I do too.
Yeah.
And petitioners' counter-arguments rest upon a caricature of the actual events. First, summum held that exercising final approval authority constituted effective control. Petitioners stipulated at PEDAP 149A that before, quote, final approval, any flag-raising Commissioner Rooney, quote, must review whether the city's decision to raise a flag is consistent with the city's message, unquote. As in summum, there is no record of prior denials, but also no record of flag raisings inconsistent with the city's message. And unlike Walker, there are no purely private messages. Second, summum looked to the general practice of governments erecting monuments. And similarly here, governments speak from government-owned flagpoles. That is what the observer would expect. Whereas Pleasant Grove made no express statement of its message, here the city has. It has a specific policy with respect to foreign flag raisings, and it has issued resolutions in connection with others. Third, as in summum, it would defeat the flagpole's essential function as the city's bully pulpit to treat it as a public forum. The city cannot effectively use its flagpole to communicate its own message if it must remain neutral and also carry the opposite message. Private parties are free to wave their flags on City Hall Plaza or even raise a temporary flagpole there, but they cannot commandeer the city's flagpole to send a message the city does not endorse. I welcome the Court's questions.
Interesting.
And I'm happy to address some of the questions that have been made.
If at any point you want to say something more specific, just yell at me or something. Do you want to say something here?
No, I think that's a pretty strong opening of the points there.
It's a position. It's a tenable position. It's a slightly surprising position. Mm-hmm. Not that I've had as much time as they have to think about it. So. Right,
and I agree. I mean, I'm coming at this completely new, right? Not having read any of the briefing. You know, this is just I'm just reacting straight off of these statements that these guys are making, the positions that they're making. But I think that's he's kind of saying what you were saying earlier, like, well, this is government speech, and so therefore, I mean, you know, where we have all the control, it's a government place. Prior case law has said that in context where we've got government buildings, we've got government monuments, the government can decide what kind of viewpoints we want to express, and that's it. Yep. So it's a very strong position, but I mean, I think that the extremity of it is actually kind of a decent point. You know, I mean.
No, I agree. I agree completely. It reminds me a lot of the general trying to pick where the battlefield's going to be.
Yeah.
And various options. It's like this is a option I didn't expect because it's kind of like fighting on your territory instead of the middle ground or something. But it's a strong option, and it has its own advantages, and it's in the abstract a reasonable option. It's just a surprising option.
Mm-hmm. Yeah.
Just yell at me if you want to say something.
Okay.
Do I understand you to be saying that to some extent the city approves of every flag that flies?
It has to confirm that raising a flag is consistent with the city's message. That's the stipulation.
All right. Well, I don't know.
A super chat for you from Phil Harrington. Legal Bites is Legal Bites' evil twin sister. What's up with that?
Legally Bites.
Back, I see.
I know. I just changed because I just remembered that I had changed that when I think it was Joe the other day that was like, hey, you should have changed everything to go by Legally Bites, like Legally Blonde, as opposed to Legal Bites. And I just remembered I happened to look at my tag, and I was like, oh, I never.
I was changing it earlier to make fun of Joe. I was doing "Come Feist Me."
Yeah, I saw that.
And I think I did Eyes Wide SCOTUS when we're talking about masks, which I thought was pretty hilarious. So yeah, I might play with my name on stream, going from whatever's on my mood that day. So we'll see.
Maybe some dispute about it, but does the mayor of Boston really approve of the Montreal Canadiens?
So the mayor of Boston made a bet with a fellow mayor and lost the bet and agreed to raise the Canadiens flag. The Bruins flag would have had to rise in Montreal if the Bruins had won. What's critical here is that of course, 90%, as Justice Breyer has mentioned, of the flags that are raised are foreign national flags. Yeah. And that it's not any individual flag that's the city's message. The city's statement of its goals is clear. It's the collective. It's the diversity.
You now say that your policy is we'll put up the national flag of any group in the community that has roots in that country, plus we'll put up flags for city holidays, and then there are a few others that don't seem to fall into either of those categories. But was there any mention of this policy as you set it out in your brief until you filed your brief?
Your Honor, that is those are the buckets that the flag raisings
I mean, that's what you've reverse engineered. But when you have explained what your policy was, it was nothing like that. There's nothing like that on the application. When you rejected the flagging question here, if I remember correctly, all that Mr. Rooney said was we won't put up non-secular flags. When he got the and that was the advice. That wasn't just something that he himself dreamed up. That was the advice he got from your law department. And then your rule number 1 of your 7 rules, and I haven't been able to find the other rules, is basically that we will put up flags that are we will not put up flags that are inappropriate or discriminatory or religious flags, from which one can infer we'll allow anything else.
So, Your Honor, to be clear, the city policy, which appears at Joint Appendix 569, states that the city, through its commissioner, may allow raising of flags to commemorate an event or occasion. And that's one bucket that we've described, these holidays or other similar events or occasions. Also, on the city's website, there is a statement of the goals of the flag-raising program, and it says, we, the city, commemorate flags of many countries. We want to create an environment.
I'm just having to say, if this comes down to what's on the city's website, with we and we.
Well, also,
if that's what turns on, Jesus Lord.
Another thought that I'm having is, if you're commemorating flags of many countries, let's say you have a significant portion of your community that is coming from a country that identifies itself along religious lines. It's a very American concept to say that we are a country by virtue of self-determination. That's a very American concept. There are many countries around the world that view themselves either ethnically or along religious lines. So,
in some ways, that's the American miracle, right?
Yeah.
Is that we are a country that's not designated by geography or by fate or by religion. We are a country that is based on a philosophy or an idea that is at the core of who we are. God bless the USA.
Yeah. But you look at a lot of countries that are, where you've got different religions, kind of coming together or rubbing up against one another. You've got a lot of countries that then identify themselves, along those religious lines. So then what do you do? What do you do then? Where you have an ethnic community? Let's say Boston has an ethnic community of I don't know, coming from a Muslim country, or a very, very strongly religious Christian country. Then you have this question of, well, we're celebrating, we're commemorating this country, but that country identifies itself along religious lines. So are you going to exclude a particular ethnic population in Boston because of that, or are you saying that we're only going to commemorate countries and ethnic groups that come from countries that are also secular, just like the United States? That's what I would want to know.
Just like the United States, depending on your point of view, is a fairly small list. Even a lot of European countries are. Yeah,
the UK has an Anglican church.
UK is probably closest to who we are. Not for least reasons we inherit our culture from there.
Yeah.
But even like Germany, France, Spain, Greece, other major countries in Europe are not really, the Nordic countries, they're not really comparable in that respect. This is one of the aspects of comparing the United States to other countries that people don't appreciate. It's like the United States doesn't do as well as, this country in this domain. It's like, well, these countries are more homogenous. They're more the same. I did appreciate. I saw this recently on someone's response where they're saying, where people are talking about the white devil and the white evil. It's like, well, what countries do it better? It's like, oh, there's countries like Norway, Sweden. So the countries that do it better are more white. It's such a great response too, because it's true. Because like you pick those countries and they are more white. I don't think they're better because they're white. I don't think countries are worse because of race or better because of race. That's ridiculous. But that's a uniquely American conceit, and
yeah,
I think the UK might be the closest, but the United States is an idea that's still trying to struggle to survive in some ways, and I don't know. I'm proud to be an American.
Me too.
It hits me here.
I love it. Oh yeah.
Screw you, rest of the world. We got it free.
Environment in which everyone feels included. We also want to raise awareness in Boston and beyond about the many countries and cultures of the world. Our goal is to foster diversity by celebrating the communities within Boston. So the foreign nation flag raising is described in the goals. It's on the city's website. The policy states we do this in commemoration of events or occasions. And so the categories we...
I could look it up, but I just prefer to ask the question blind. They said that they raised the flag of Cuba. I wonder if they've ever raised the flag of Israel.
Given are explicit there. And moreover, the rules are actually a subcategory. The policy incorporates the rules. And then under the policy, the first rule is that the city will not put up a flag that is discriminatory, offensive, or that supports religion. It's that the city is going to stay silent, neutral with respect to religion. We're not going to support a religion, neither will we offer something that is derogatory of religion. And that's consistent with the principles of the Establishment Clause.
Well, is it consistent with the principles of the Free Speech Clause? If you say anybody can speak, except we are going to monitor what is said and we're not going to allow religious speech. I mean, the court has said you can't do that in Rosenberger and other cases. Plus, we're not going to allow speech that is offensive. And we've said that that's viewpoint discrimination in our two most recent cases that have a bearing on this.
And the party stipulation makes clear that religious events are allowed in the public forum, in the City Hall Plaza, around the flagpoles. Religious events are allowed. The city's own speech will not support a religion. So the First Amendment doesn't...
I understand that, but when you say anybody can speak by putting up a flag, with these few exceptions, are you not creating a forum for private speech rather than speaking your own mind?
No, Your Honor. I do believe that the fact that we're talking about the government's own flagpole in front of the government's seat of power, where governments have historically spoken, it's the government's bully pulpit. Everyone would think that is the government speaking. We're not taking anything from the public when the government says we will speak here in certain ways. One of the ways we, the city, speak there is to allow the flag raising of foreign national flags, to celebrate the diversity of the communities in Boston. It's not those governments, it's the communities in Boston.
But do you think the fact that it is a flagpole in front of City Hall is dispositive?
I think it is almost dispositive, Your Honor, because I do think that all observers would understand that that is the city speaking. Again, 90% of the time, the city of Boston flag there, or more, flies there next to the flags of the United States and the Commonwealth. The fact that occasionally, and again, physically, the city must lower its own flag and provide the crank to allow another to go up in its place. The city maintains physical as well as regulatory control over the flag.
What is the difference between that and a program that allows people to speak in front of City Hall and say whatever they want, but not certain things that the city is going to rule out? That's government speech?
No, Your Honor, it's not, because that's a traditional public forum.
And I think on your property, right in front of City Hall.
Well, most public forums are government property.
Right, you've designated it as a public forum, but let's say it's not. But you allow it for that one purpose.
I think most public properties, including in front of City Hall, would be a public forum, because that is where the citizens can protest their government. That is their right.
It's a bit of a, it's not a bad answer, but it's slightly annoying because it fights the hypothetical, right? Because the hypothetical is assume that you've designated this limited purpose forum and these other things are true, and then they say, well, that should be a general purpose forum, which fights the hypothetical.
Mm-hmm.
Am I alone?
No, I think, yeah, he doesn't really want to play within the sandbox that's created for him.
No. It's not a bad answer for him, but it fights the hypothetical. It's worth noting.
Yeah.
So should I praise it or condemn it?
I mean, from his perspective and his advocacy, he's presenting his case regardless of the questions that are thrown at him.
Fair enough. We will praise it for a good turnaround.
Yeah.
All right.
And so in summum, what the court insisted on in terms of permanence, et cetera, was something was being removed from the public, taken from the public. Otherwise, this is public forum. Something's being taken away. Nothing's being taken away from the public when the city of Boston says we and only we will decide what we say from our flagpole.
Counsel, could I just ask a question? Because I've wondered about this from the beginning of the case. I thought we were ruling on whether the First Circuit, on the basis of the summary judgment motion and the evidence before it, whether that policy was constitutional or not. But you've been arguing not the old policy, but the new one that changed during this litigation. What are we ruling on?
Well, Your Honor, the parties stipulated that the written policy, which was written down in October of 2018, was the same as Boston understood the policy to be at the time.
I didn't know if you want to say anything or not. I wasn't trying to ignore you. I just didn't know if that was a please stop.
Oh, I mean, not necessarily, but I think that's a very interesting question because, I mean, they've got to be clear on what exactly they're answering here, right? And so, I mean, it sounds like the messaging from the city of Boston has changed throughout the course of this litigation, which would not be proper. So that potentially could be putting him in the hot seat. I don't know, depending on how this conversation continues to go on.
Very much so.
Yeah, but what you understand and what you did are two different things. And assuming that I think there's a difference between the two. What am I ruling on?
Well, Your Honor, I think the parties have stipulated that it's the same policy. We believe it was the same policy. The fact that Mr. Rooney cited the Establishment Clause, I think, is further evidence that he thought it was the city speaking, because the Establishment Clause would only limit the city speaking. And so I think...
Well, he can speak for himself on this point. But you're believing that we're ruling on the policy as it's written today, not the policy that we understand the summary judgment history related to, correct?
Well, because the parties stipulated that the two were the same, I think that there's no difference between them, Your Honor.
On the Establishment Clause point, it seems to me that maybe the root cause of this, as some of the amicus briefs suggest, is actually a mistaken view about the Establishment Clause, that when you have government property that's opened for a forum for speech or for use, there's a mistaken understanding that has existed that if you allow a bunch of secular groups and then allow a religious group to use it, that you violated the Establishment Clause by doing that. It seems like we've had case after case after case that has tried to correct that misimpression of the Establishment Clause, and that seems to me what the root cause is here. I think the Beckett Fund amicus brief is pretty helpful on that. I'd be curious of your thoughts about that.
Your Honor, I think that the Establishment Clause was cited by the city because the city did not want to be accused of having endorsed a religion. The proposal was to fly the Christian flag, but then the city thought that it was the city's own speech. And if the city, speaking for itself, was to say, we are flying the Christian flag, we the city are flying the Christian flag, not one that's had its religious intentions removed.
I'm sorry, did you want to talk about something? What do you want to talk about?
I don't know. Let's talk about looking for new chairs. I'm sorry. Just a light ribbing, that's all. At first I was worried because I was like, oh no, did the stream get taken down for some reason?
Look, the chat's already busting my ass as I realized, because, okay, just for the record, in case you're interested in the technical aspects of this, I scheduled this originally in YouTube Studio, not within StreamYard. So in order to accommodate Legal Bytes, I'm capturing this window and I'm transforming it into OBS, and I'm streaming this in OBS. So this is the hardcore way. I'm not streaming this in StreamYards. It might look like I'm streaming with StreamYards, but it's a deception. It's really OBS. So yes, that means that as I'm opening up other windows and seeing other things, you're seeing other things that the stream. Yeah, there were some complications.
I'm just giving you a light ribbing, just to give an opportunity to so that we can all laugh together.
So I was interested, maybe I was interested in the Herman Miller gaming chair, and I was interested, because I'm what people might not know is I'm physically moving my apartment, and so I'm interested. This chair, which is I think AK Racing. I've had for a year, and it's not the most comfortable chair I've ever had in my life, to be quite honest. So I'm debating between the Herman Miller gaming chair, which is like $1,700, and I'm also looking at the Titan from who's it from? I can't quite remember the brand name right now. Huh?
Attorney Tom's in the chat.
Yeah, Attorney Tom's here. Hello, Attorney Tom. How are you doing, Attorney Tom? Would you like to join the stream? I'd be happy to give you the link if you like. I'll send it to you anyway. So anyways, I was looking at the... Yeah, no, so I was looking at the Titan from... whose name will escape me, but it's like a $600 chair. And so I'm like, do I really want to spend like 2.5 times as much for Herman Miller? So, yeah, that's what's going on there. And I'll send Attorney Tom the link in case he wants to join as we celebrate my exposure of
through the force of history, but one that is right out there. We are flying it as the Christian flag. That might raise Establishment Clause concerns, I think, was legitimate.
But isn't the answer to that what we've said repeatedly, which is equal treatment of religious groups vis-a-vis secular groups, religious speech, religious organizations, there's an open gym policy and a religious group wants to use it and they're excluded because they're religious. We've had cases like that. Isn't the answer to that to say equal treatment of religious groups or religious speech is not an Establishment Clause violation, to reiterate that?
It is absolutely clear that if this is a public forum of any type, limited or general designated, the city does not maintain that it has a basis to exclude religious speech. And it's also clear that the city does not exclude religious groups from proposing to raise a flag. In fact, in connection with Constitution Day,
Now, I thought I had solved this issue, incidentally, because I thought I was capturing a different window, but apparently, no. Okay, I don't know what happened. Things happen. Mistakes are made by me. It's all bastardized when you're trying to capture a Streamlabs window within OBS, blah, blah, blah. And then, of course, inside... So I'm capturing OYE inside Streamlabs and then streaming that into OBS. Mistakes were made by me. That's fine.
City said it was willing to raise a flag of Camp Constitution in celebration and recognition of Constitution Day, notwithstanding.
You're saying, Mr. Holwood-Driemeier, that we should recognize as government speech a program that basically now says, and previously, we welcome all comers except for the most reprehensible discriminatory speech, and religious speech. That's what this program is. And why should we understand that to be government speech, to say everything's good except religion?
Your Honor, the suggestion that the policy ever said that flag raisings were open to all comers is a mischaracterization of the documents. There are documents that relate to seeking a permit to use the space at the flagpoles. That is a designated public forum. It is open to all comers.
So Counsel, if I understand your response, and I don't mean to interrupt, but your argument to Justice Kagan seems to hinge on a factual premise. Is this flagpole, in fact, open to all comers, more or less? Is it a public forum? But once you, say, lose on that point, is your answer to Justice Kagan, you're right, we can't discriminate against religious movements and treat them as other offensive and viewpoints?
If the flagpoles had become a public forum, that was not our intent, but if by miscommunication the flagpoles were deemed a public forum, the city acknowledges it cannot exclude religious speech, it cannot exclude offensive speech or discriminatory speech from the flagpole, because it has to be viewpoint neutral.
And then let's just back up again. Just now grant you your premise. In what case, what authority would you cite to support that the government can, in any circumstances, treat religious viewpoints the equivalent of offensive or inappropriate ones?
They're not equal, Your Honor. They are just categories of speech that the city will not itself espouse.
How is that not viewpoint discrimination under our case
law?
Well,
Your Honor, if it's the city itself speaking, then Summum said, and I'm quoting, the city is free, quote, to select the views it wants to express. So the city, for the city's own speech, can be viewpoint discriminatory. I don't think it's discriminatory is an odd word to use when describing a government's own speech. The government is simply fashioning its own message. And it has to be allowed to do that, or the democratic system breaks down, Your Honor. So that's why I say whether this was government speech or private speech is dispositive of the outcome here, because
so you've said that if you lose this case, you would restructure your program so that you would be able to exercise the kind of control to exclude religious flags, like the one that Camp Constitution wanted to fly. How would you propose doing that?
Well, Your Honor, the United States has proposed what they view as a greater level of governmental involvement.
I know. I read the SG's brief, but I mean, what's the city's position?
I mean, if the court clarifies that that type of involvement is required, the city is happy to include that in its program. I think that what we've described is that, in fact, when apart from the foreign flags, that is a different sort of message that the city is sending, that the third-party flags were raised in connection with a city resolution or other recognized public observance. And so I would have no problem, I think the city would have no problem making that explicit in its policy. This is our speech. We will decide whether and when to do it. One could add the layer of requiring a city official to sponsor it to the city council, to attend the event. Those are all available, and I think the city would be willing to make clearer, if necessary, that it is the city's speech. But someone talked about not thinking of something as a public forum if calling it a public forum would make it impossible, it sort of defeat its essence and effectively result in the removal of the forum. No city, Justice Kagan, I think you are exactly right, no city can run the risk of being forced to fly the swastika in front of City Hall. And so you cannot have a public forum at the City Hall.
Well, I wonder if you think I'm exactly right if I say the following. And this really does go back to Justice Kavanaugh's point, because the reason I said, why wasn't this settled is because my guess is the same as his, that this all came about because of a mistake by Mr. Rooney. And it's actually an understandable mistake. We have a line in one of our opinions that says a city hall can't can't have a cross on the roof. And so somebody looks at this, Mr. Rooney looks at this and says, isn't this kind of the same thing, and prohibits it. And in fact, it's not the same thing, because it's in a flagpole where different flags are coming up and going down all the time and expressing a wide variety of views and organizations and so forth. And so this was a mistake. And why is it that people have not been able to correct this mistake?
Your Honor, the city would be very happy.
Go ahead.
I mean, it sounds like Kagan is coming down on the side of the petitioner here.
I think realistically, you're looking at a 9-0 decision of some variety.
You're
quite
muted.
honest. Oh, sorry. I think realistically, you're looking at a 9-0 decision of some variety.
Yeah.
It might be a fairly fact-specific, fact-driven analysis, but I think realistically, you're looking at a 9-0 to reverse.
And they might actually take this framed as an establishment clause issue, saying this is not. Specifically, this is not an establishment clause issue, because her distinction right here is actually pretty, I think, pretty simple and pretty reasonable to say this is not the same thing as a city hall putting up a cross over it to show that it is establishing a particular religion. This is a temporary thing where they are allowing some flags to go up and down on a fairly regular basis, and they're inviting other people to do that, and so it's not, it wouldn't be reasonably seen as these are points that are being I guess endorsed by the government, and that and man, Attorney Tom keeps getting he keeps getting timed out by your chat.
No, he's timing out people now.
Oh,
you're misreading it.
Oh,
you're misreading it.
Oh,
I made him a mod. He's timing out
gave
everybody.
him a wrench. Oh no.
Well, I do have a standard policy. I mean, I do have a standard policy of giving all my LawTube members a wrench.
Do I
and
have
it's
a
just,
wrench? I do. I do have a wrench.
Yeah, you do have a wrench. I give all my LawTube members a wrench, because we're in a partnership together, camaraderie, and
I do the
brotherhood.
same thing.
And
I do the same thing. Oh, that's funny. Oh man, he's drunk with power now. But I think that framing this as really an establishment clause issue rather than a viewpoint discussion issue is, I think, very, very interesting. So Kagan's point is pretty so funny.
Attorney Tom, for you, in all honesty, Attorney Tom, for you to get demodded, you'd actually have to work pretty hard at not being my friend anymore. And I don't think either of us want to go down that road. I genuinely respect Attorney Tom. I genuinely respect all of LawTube, and for you to demod would have to result in a serious schism. So let's try not to do that, because that sounds like a bad plan. I don't want to have a serious schism with Attorney Tom. He's my friend. Please don't stab me in the back, Attorney Tom. That'd be great. I love Attorney Tom and I love Nick Rekieta. I love them all. It's fine.
Also, I've gotten there's a question in the chat about if I'm distancing myself from Rekieta Law because it's not PC. Some people have asked me if I'm like mad at Rekieta because I haven't been on his channel.
I think Emily D. Baker's mad at me.
Oh really? Well, no,
Yeah.
but the question was about. I've gotten some questions about whether I'm like trying to avoid Nick Rekieta. That's not the case at all. I just haven't really been available at the times that he's been streaming, because I've been trying to hit a balance because of my time zone that I'm on. I've been trying to hit a balance.
I mean, we all have commitments. I've popped in a little bit, but I tell you what, the last month I've been, and in some degree I've popped in specifically because I've been burning myself out completely, and I look to LawTube as a way to have some fun and release, because I really enjoy it. But I tell you what, the last month because I had a 15th drop date. I talked about it a couple times on chat, a couple chats. I had a 15th drop date, and I was burning myself out so hard, and just to be able to go to other people's streams and hang out, get some relief. It's nice.
Yeah. Well, for me, after the Rittenhouse trial and the Potter trial and everything, I was really trying to stay up on everything. And trying to balance that with content on my own channel, plus other stuff, plus my time zone. I wasn't getting any sleep. Like I was getting. There was a period of time before I left for Christmas vacation that, for actually a good long while, that I was basically getting like newborn parent sleep. I was getting sleep in like 3-hour spurts.
I feel
and that was not good for my overall health. And that's some people have also remarked about how I haven't been doing my running challenges for my milestones. That has a very strong connection there. So I'm trying to get myself back into healthy sleep habits.
It can be a lot of work. What you see on screen. The live streams obviously are not so bad, but the editing takes a insane amount of time. It makes me want to hurt myself a lot. But yeah. And then my editing sucks, so I can't even imagine the people who actually try to edit with like quality or something. But Attorney Tom, I am trying to hit 50K subscribers tonight. I am currently 37 subscribers away from 50K. So Attorney Tom, if you could try not to destroy my chat as I'm trying to hit 50K subscribers, I would really appreciate it. Let's go back to the video.
Happy to discuss settlement. The city proposed them. I was not part of those discussions. I just know that they happened. I think that the suggestions for clarification, greater clarification, that the policy is as we represent it to this court, that it is effectively flags of foreign nationalities and flags raisings in connection with something that is a public holiday or something where the city has passed a resolution stating our support. We would be happy to clarify that policy in that way. What the city cannot afford is the idea that the flagpole has become a place where, to use your Honor's hypothetical, the swastika flag, to use the example of Walker, the Confederate flag, ISIS, Al-Qaeda, all of these could be flown. And it's not to say that the Christian flag is any of this. As a person of faith, that is not what we are saying. What we are saying is that the outcome in this case has to be the same, whether this is the Christian flag, the Summum flag, the Confederate flag is in Walker, or the New York Yankees flag. The city is either compelled to raise all of them or none of them, because it's the city's speech. The city feels that it must.
Whether it is or is not the city's speech it's from his framing, and it's a bold framing. But yeah, that's the ball game. If it's the city's speech, they can do whatever the hell they want. It's their speech. If it's not, then he's absolutely correct. They cannot viewpoint discriminate. That comes from the flag burning case. That viewpoint discrimination is a total non-starter.
Yeah.
It's per se unconstitutional, right, if you read the case law. So you can't censor based on the fact that it's pro-America or anti-America. You can restrict subjects. So you could, for example, not allow any country flag. That'd be subject matter. You could allow only flags that promote the arts or something. But you can't choose a viewpoint. So if you say all flags that deal with arts, it has to be pro and anti-art. And from his frame, it's either city speech or it's all allowed. In which case, Boston would respond with, then none of it's allowed, which might be the right answer. But that's the analysis, right?
Yeah, that seems about correct.
Yep.
Retain that control. It felt that it did have that control because the parameters were clear enough. From 2005 up to...
really wants to align itself with every national flag that members of the community want to fly, and yet you're willing to do that, right?
Well, because, and this is why I think the goals, as explicitly stated on the city's website, are important, because they say that it is to celebrate the diversity of the communities in Boston. It's not an inconsistency to put up the PRC flag and then put up the flag of Taiwan, because Boston is not celebrating either of those governments.
If somebody,
it's the communities here.
someone in Boston wanted you to put up the North Korean flag, would you do that?
I
don't know what the current flag of Afghanistan is, but if it becomes the Taliban flag, would you fly that?
ISIS?
If there was a community in Boston that sought to, they may be refugees from those countries. If they sought to raise a flag, the city would do
Good
so
answer.
in honor
There's a
of
few
the
North Koreans
community
floating
here
around.
and where they came from. That's the message that the city of Boston is saying. And the fact that the reasonable observer would think that this was the city speaking, Petitioner Shurtleff, the Massachusetts brief cites his own letter to the editor complaining about saying he's ashamed of Boston for having flown the PRC flag. Based on that, I went on did a search. He's published another letter more recently in which he says, call your counselor and tell them to stop this. He knows that it's city.
Do you think that every national flag that has religious symbolism has now been drained of its religious significance?
It's not religious symbolism in the context of this flag-raising policy, because the policy, as Mr. Rooney made very clear, it's the city is flying the flag because it is the flag of that.
No, but
other
I'm just
country.
getting at what the reasonable observer would think.
I don't think that the reasonable observer would think, because the Boston flagpole was flying the flag of Turkey, that the city of Boston had declared itself Muslim. It's flying. Okay. They would also know, if they know anything, that they're flying other nations' flags routinely throughout the year, because if they went to the website, they would see it's about celebrating the diversity of communities in Boston.
So who can fly? What exactly is your policy now? National flags, city holidays, anything else?
The policy says that it's raising flags to commemorate an event or occasion. That's the paragraph 1 of the city policy. This is at
any event or occasion.
Well, Your Honor, it's the city retains the control, and that's explicit. That it's.
But this flag was for Constitution Day, right?
That's
why wouldn't that count as an occasion?
And the city said that they would fly a flag for Constitution Day, and they offered that if you had offered the Camp Constitution flag in honor of Constitution Day, that they would have flown it, because the city is already supporting Constitution.
Right, the city would have flown that very same flag
if it had been presented as the Camp Constitution flag.
Interesting. Now that's a problem. That's a problem for the city. That's a massive problem, it seems to me. Okay, so the name of the place that wanted to do is Camp Constitution. That's the name of the organization that wanted to fly this flag, in case that was missing. All right, so they're called Camp Constitution. What they wanted to fly was the Christian flag, which is the white. It basically looks like the white surrender flag, except in the upper left corner, it's a blue with a red cross on it. Now, what he just said. What they were just saying was, if they didn't offer it as a Christian flag, if they offered it as a Camp Constitution flag, we would have offered it. That defeats so many of the arguments, because so many of these arguments were based on what a reasonable person would observe from the, going along in the crowd. What a reasonable person passing by would see. They would see a flag that looks suspiciously like the Christian flag, and they would think it's the city speech.
Mm-hmm.
And so that I feel like this concession, maybe it's just me, maybe I'm overreacting, but it feels like a huge concession. It's because they called it the Christian flag. It's not even because of what it is. Literally, it's the same. I mean, tell me if I'm misreading what he just said or mishearing.
It sounds like it would have been the same thing, but they just would have called it something
literally
different.
the exact same flag. But if we call a rose by any other name, would it smell sweet? Is basically what we're doing right now.
Well, right. Yes, exactly. And that's a decent question here, that a reasonable person just kind of driving by City Hall and seeing the flagpole would have seen the exact same thing. Like, yeah. It's not like they also put up a sign saying this is the such and such flag. They don't identify.
It would depend on them seeing the sign, right?
Yeah.
Yeah. I mean, this feels like such a huge blow. We would have. How do you defend? Okay, the government. All right, the government is entitled to any speech it wants. we would have approved the exact same flag. It would have looked exactly the same on the flagpole. Any reasonable person passing by would have seen the exact same flag because it is. We would have approved the exact same thing, but you called it the Christian flag, not the Camp Constitution flag. How the fuck is anyone passing by supposed to know what they called it on the damn application form?
Yeah. Because if it's two different flags that are flown by the same organization, that I could see the distinction. But if it's literally the same flag and they're just calling it something else, that's a distinction without
it's a distinction without a difference.
Yeah, exactly. I was trying to search.
I might as well call you legally bites for all the difference it makes. This is mind. I mean. This is so mind-numbing, and because this argument has been really, really high level, and this feels like, what the hell just happened right here? What the fuck is this? Amy Coney Barrett, but this flag was for Constitution Day, right? Douglas, that's so. Amy Coney Barrett, why wouldn't that count as a Constitution? Douglas. The city said it would have flied a flag for Constitution Day, and they offered it if you had offered the Camp Constitution flag in honor of Constitution Day. They would have flown it because the city's already supporting the Constitution Day. Neil, right? The city would have flown the very same flag, right? Douglas, if they had presented the Constitution flag. What the fuck is up with the fucking flag?
Oh man, I'm looking up the Camp Constitution flag now to see if. Oh, no results? Oh, come on.
What kind of concession is that?
Yeah, no, it does. Wait, bring up the words again on the transcript. If it had been
Neil says the city would have flown the very same flag, right? If they presented the Camp Constitution flag. Yeah. What kind of fucking concession is that? Holy shit, way to shoot your whole fucking argument in the fuck Christ!
We love you, Kurt. And that was the day Kurt's brain exploded. You okay? Do you need a minute?
Inspiration behind the flag, right?
Well, they didn't say that there was religious inspiration behind the Camp Constitution flag. They didn't say it was the Camp Constitution flag. They said they wanted to fly the Christian flag.
Yeah, but if it had been presented as a Constitution camp flag, it would have been approved, I believe. You've said a couple of times.
Yes.
Okay.
Wow.
And so I want to get back to Justice.
Kurt, this is why you need some kind of a pet, a dog or a cat. Oh no, Kurt, come back, Kurt. It's okay, Kurt. It's gonna be okay.
We would have flown the exact same fucking flag if they just call it something else. It's not a rose. It's a daisy. Because we called it a rose, not a daisy. That makes it different because we called it a different thing.
Yeah. Oh, man. Oh, man.
Kagan and Justice Kavanaugh's point. Mr. Rooney apparently denied the request because he thought the Establishment Clause required him to do so. And if that's mistaken, And if we all agree that that's mistaken, and that was the basis on which the city's application decision was made,
bye-bye.
What's left to decide?
Well, Your Honor, the city made clear that the city, for the city's own speech, was respectfully refraining.
No. 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 No, you can't do that. You can't do that. You can't do that. You can't do that.
What can't you do, Kurt?
You can't. You can't do that.
What can't he do? What can't he do, Kurt?
Okay. All right, so there's a very famous case called Smith. Smith stands for the proposition you can't treat religion worse than its secular counterparts. You can treat it the same. You can even treat it better. Better is okay, but you can't treat it worse. And they literally just said to the U.S. Supreme Court, the reason we didn't do it was because religion. So you're flying into the Smith. Face forward in Smith. Holy shit. And we would have done it. We would have, and not only that, it's because you called it religion.
Yeah.
So if you had called it literally anything else, we would have been okay. But you called it Christian. You called it religion. If you called it the Camp Constitution flag, we would have been fine. But you called it religion. So we're flying face forward in Smith. Holy fuck. How can you take this incredibly nuanced argument?
This is the nails in the coffin.
No. Legal bites. How can you take this incredibly nuanced argument where earlier in the stream before you joined, like just before you joined, in fact, which is why it was like fresh. How can you take this incredibly nuanced argument with like, geez, Craig, I got these 2 points and it's like, you know, I got this balance and I got this tension between these two things and there's a conflict here. It's a clash of the ages, clash of ages, and you take it, you just go, it's all gone. It's gone. And we're turning front gay.
It's just someone just took a giant club and was like, boom, blunt force. It's because I got here. That's why, right? I chose my timing perfectly.
I mean, the city's proposition of this is the city speech or not, I'm like, but it didn't require this. I mean, that was a bold. I don't even know what this is equivalent of. I just.
Yeah. Yeah. I think this argument has effectively been nuked. You okay, Kurt?
No.
What's going on? What's going through the brain?
Suicide is painless. Bring so many changes. I could go leave the rest up, please.
From speaking on the subject of religion. That is absolutely consistent with
as
this
I understand
court's
it,
precedent.
Mr. Rooney said that he thought it was concerned about the so-called separation of state, church and state, or the Constitution's Establishment Clause.
And
I think that's from the record. And if that's correct, and we all agree that that's a misunderstanding, forget about the future policies or whatever they may be. Why doesn't it resolve this case?
It is not an inaccurate understanding of the Constitution to say that the concern about the separation of church and state leads us, as the government,
I
to
thought
be
we agreed that
silent.
in a public forum,
Oh, I'm sorry.
That Boston would, and assume a public forum.
Yeah.
Okay, assume a public forum, and the record shows that the denial was made based on a misunderstanding of the Establishment Clause with respect to public forums. Why isn't that just the end of this case?
Your Honor, if it's a public forum, the city acknowledges it has no basis to exclude. The Establishment Clause would not provide a basis to exclude a religious.
This is law by magic words. But I this might be the dumbest version of law by magic words ever. It's law by magic words. It's like if we conjure the right words, it's a goddamn Harry Potter spell. And if we call it religion versus if we call it the Camp Constitution flag, it's one thing. But if we call it the Christian flag, it's another thing.
Yeah.
And by the way, we're doing it specifically because they call it religion, which we specifically labeled, which we put in the same category as offensive things, which is.
Yep.
Hocus pocus, this is bullshit focus.
From a public forum. I want to be very clear. The city does not think so. The fact that he cited the Establishment Clause was because he believed it was the city's speech, and the Establishment Clause does apply to the government's own speech.
And I mean, one could add to what Justice Gorsuch just said. The fact that it was a public forum doesn't mean it's a public forum for all time in the future, right? The city can decide whether it wants something to remain a public forum.
We think
but if you look at the lack of control over this flagpole, it's hard not to think of it as a public forum, and then it's hard not to think that excluding religious speech from a public forum and particularly excluding it because of this mistaken view. And again, I want to say it's not a crazy mistake. You know, a city could not put a cross, in my view, on City Hall. But in the context of a system where flags go up, flags go down, different people have different kinds of flags, then it is a violation of the free speech part of the First Amendment and not an Establishment Clause violation. The end.
You know, I would like to take issue with the idea that there was no control. I mentioned the stipulation in which it was stipulated that he had to review it for whether the city's decision to fly the flag was consistent with the city's message. That was in Mr. Rooney's affidavit as well. And there was a deposition taken of Mr. Rooney. And one subject they never asked him about was, what do you do to make sure that it's consistent with the city's message? They never asked that question. And so it's stipulated at 149A that he would review to make sure that the city's decision to fly the flag was consistent with the city's message.
Apparently, consistent with the city's message would have comprised completely of, this is the LGBTQ flag. I know it may not look like it, but we're calling it that because we can. Because all we call it is what matters, right, Alita?
Oh, you mean like if we were to use the same flag in question here and just
No,
call
that's
it
exactly what I was
LGBTQ
trying to go
flag?
for, yeah.
Yeah.
No, that's exactly what I was trying to go for. Yeah, this is not the Christian flag. This is not even the Camp Constitution flag. This is the LGBTQ PA plus.
These are not the droids you're looking for.
Circle star emoji flag.
Yeah. Yeah.
I have 9 more minutes of this.
Counsel,
also
the problem you have with that answer is that the city's message
You got
was
it,
diversity
baby.
of views
Pour yourself another
and
one.
backgrounds.
Fuck.
And clearly religion was one of them. You have no problem, and he had no problem with raising flags that had religious symbols on it. You had no problem with having religious groups speak. His only problem was, as Justice Gorsuch pointed out, was this mistaken belief that the Constitution required that the city not raise a flag that had a cross by a religious group.
No, it's not. That's not the problem. We would have been happy with the cross if it was the Arbor Day flag, or the Daughters of the American Revolution flag, or even the USA flag. It's the American flag. Goddammit! Do you know what the American flag looks like? It's a white flag with a blue section with a red cross in it. Fuck. That's the American flag. God bless USA. Shit.
That's a very different and substantially unsubstantial. I'm sorry, let me rephrase that. that belief is the one that Justice Gorsuch was challenging.
Your Honor, I think that with respect to the foreign government flags, yes, it's diversity of those, the national origins of communities within the city. But that's a distinct thing. That's one message, and is reflected in the city's goals document that does, in a sense, require that diversity of those national origins. But with respect to the other aspects of the program, which were to celebrate events or occasions, doing it on public holidays or in connection with a city resolution, every other flag that they identify is connected with a city resolution. That's true of the EMS flag, the Mother's Day flag, the Bunker Hill, Juneteenth, Malcolm X, the Renegades.
The EMS flag, the Mother's Day flag, Bunker Hill, Juneteenth, Malcolm X. And I don't even know what the Renegades are. What the fuck is a renegade?
I don't know.
Is that a Boston thing referring to some period of history that I should know?
I am not familiar.
How do you not know what the Renegades are? They're a massively important part of U.S. history. How do you not know, Lolita?
How do you not know? Uncivil law.
Then they cite two flags in their reply for the first time in this litigation. Donate Life. There is a federal Donate Life month. The application, this is at JA 398, refers to the fact that there is going to be state officials at this celebration of Donate Life. Of course, Donate Life is carried out through the Registry of Motor Vehicles and your driver's license. That was a public event. The Metro Credit Union, during Hispanic Heritage Month, the Metro Credit Union, which is a city community lending partner, said we wish to fly the Juntos Avanzamos flag. Together we advance, in celebration of the fact that that is the first financial institution recognized for its outreach to the Hispanic community. That, too, was a public event, Your Honor. They cite it at the last minute, and the document that discloses this is both the article that they cite in their brief and also a document produced in Discovery COB 6536. Your Honor, this record shows, as we have demonstrated, that if you take the national flags aside, there is about 10 other flags. And we have demonstrated that they were all in connection with something that had a city message, the celebration of a particular day, an observance, a remembrance. There is not ever a suggestion that the City Hall flagpole was open to all comers. Thank you, Your Honor.
Thank you, counsel. Justice Thomas?
Mr. Hallward-Driemeier, just briefly, you mentioned diversity several times. And what I don't understand is your definition of diversity, because it would seem to me that Christians in Boston would be a part of that diversity calculus.
The specific form of diversity that the city was trying to celebrate was national origin diversity, the references to countries throughout the world. Of course, there are other aspects of diversity. The city can choose to celebrate those aspects of diversity in many ways, and the city does celebrate religious events in other ways. There have been religious events that have happened on city property. The city chose not to start down the road of speaking on the subject of religion from the flagpole. Of course, had they started down that road, then the argument would have been that they had to carry all religious communities.
Apologize. What
yeah.
were you saying?
No, I was just saying. I mean, then he said that the city has had celebration of religious communities and other parts of city property. But then I'm like, well, then what's the difference between that and the flagpole? Because that seems like a bit of a concession, because then it's not so much of a forum issue if they're allowing it elsewhere.
I mean,
but then they're concerned about the establishment.
It goes back to the fundamental framing premise, which we'll try to remember because I don't want to focus on anything else at the moment because reasons. But the fundamental framing premise was it was government speech. So if it's government speech, then the fact that they speak differently in one place versus another is irrelevant. Because I can speak differently one place or another. I can speak differently on Twitter or YouTube or Locals. You can check me out on uncivillaw.locals.com, and I can speak differently there, or patreon.com/uncivil. Or, you could subscribe, because I need another 27 subscribers to hit 50,000. So if you're not a subscriber already.
27? I thought it was only 7.
Well, the number changes constantly.
Oh, that's true. That happens to me too.
The number changes constantly. So if I could impose on you to please subscribe, if you're not subscribed already. We are 27 away from 50,000. I'd like to hit 50,000 by the end of the stream. I did a whole freak out thing. I beat my head against the wall. I get my head against the wall some more. I will flog myself. I will humiliate myself for subs. At this point, I don't care. What do you want? What do you want for more subs? I'll do whatever you want. Legal bites.
So if you let's go back just a couple lines. I mean, you don't have to play it, but just scroll up a little bit, because I want to. Maybe I misinterpreted what he said. But if there's a way to scroll up just to show the words.
Sure. Where do you want to go back to?
Right here this is fine. So there have been religious events that have happened on city property. The city
I will
chose
get
not to
a
start
belt.
on that
I
road.
will get a belt, and I will fucking flog myself.
Oh.
Test me. Test me.
So, the city can choose to celebrate those aspects of diversity in many ways, and the city does celebrate religious events in other ways. The city does celebrate religious events in other ways. That's okay. There have been religious events that have happened on city property. The city chose not to go down that road for speaking on the subject of religion from the flagpole. So it sounds like we're not talking about just the public park here. We're talking about government property. We're talking about the city. The city, he's saying the city does celebrate religious events in other ways. So how is that different than this commemoration, this celebration at the flagpole?
Yeah, I mean, again, it goes all back to the fundamental premise from the city's perspective, where they once had a point. So if we can forget the point where they completely lost all rationality, if we can ignore that for like 5 minutes in time, back to the beginning. If it is truly the city's speech, then the fact they speak differently at City Hall versus anywhere else is irrelevant. Because again, I can speak differently on YouTube, I can speak differently on Twitter, I can speak differently on Facebook.
Well, but
it's my speech. I can speak differently anywhere I want. I can have different personalities. Fuck you.
I guess I'm not understanding your point as it relates to the government, though.
Well, no, I maybe I'm misunderstanding your point. Maybe that's the problem, because I thought your point was the fact that they spoke differently at City Hall versus somewhere else was the issue.
Well, no, I mean their justification for not allowing this at the flagpole is that they don't want, that the government has the ability to speak on its own terms.
It is a bit. I do understand there's a bit of a contradiction. There is a bit of a contradiction. There is a bit of a contradiction here where it says the city can choose to celebrate this in many different ways, because the city could. I guess the way to square it is because the city could choose or not choose. Mm-hmm. Because it's up to the city. So the fact the city has chosen would be irrelevant. We've done it, but we don't have to. So we could go with we're not going to recognize any religion ever policy.
Yeah,
we've done it before, but so what? It doesn't matter. It's our speech, so it doesn't matter.
It just, to me, it seems like the policy as it relates to specifically the flagpole, it wears away against their argument about the flagpole if they say that they do it elsewhere.
Yep. Well, I mean, maybe not. I mean, they'd have to potentially show why different venues are different, but if we can just go back to it's my speech, we'll just make it simple, right? It's me, and I'm not a government actor, right?
Yeah.
So the fact that I, in my own providence, choose to do something on YouTube versus Twitter versus Twitch versus whatever is irrelevant. I can choose to have one persona or one expression somewhere else, and I could be a totally different person on Twitch if I wanted to, or Facebook. I could, and it wouldn't present a problem because it's different. I'm playing different characters. It's fine. It doesn't matter. It's my speech. I can do whatever the hell I want. So if we take that from the city's perspective of they have different perspectives of different places, it presents some issues maybe as to why, but fundamentally they can do what they want to do. Or am I missing something?
I guess it's just the logical reasoning behind denying it at the flagpole just seems like it kind of cuts them at the ankles, it seems like.
Well, among the many, many, many problems tonight, that is the least of my problems. That is not my problem.
Yeah.
I mean,
the fact that the fact that I'm completely inconsistent from YouTube to Twitch to Facebook to Twitter to whatever. If I'm 1,000 different people on 1,000 different platforms, that is not the problem. The problem is apparently the fact that I think a rose is a potato, and that makes a difference. Or that you can label a rose a potato.
Right. And if it's a potato, it's different, even though it's a rose. But I call it potato because magic. Because I speak the magic words with
mashed
the proper
roses
incantation.
probably wouldn't taste the same.
Yes. You know, if I say the magic words in the right order, it totally changes. This is law by magic words is breaking my brain, and yeah, no, it doesn't make sense, and I hate it.
All right.
The problem isn't that we flew different flags at different places. The problem is we would have flown the same flag
if you had just labeled it on the
form differently. If we called it a different thing.
Yeah.
It's Capulet, not Montague.
Yeah.
Kill me.
Communications because they couldn't prefer one religious communication from the flagpole, or at least that would have been the argument. They simply chose not to go there.
It's limited diversity.
They're celebrating a particular kind of diversity, national origin diversity.
Yeah. Justice Breyer?
You mentioned the website, which had a good statement of the policy. Was that put up before or after this case began?
The policy.
Well, that definitely makes
I'm not
a
saying
difference.
about the policy. I'm saying was the website.
Jesus Christ! What's the most aggressive thing that I can say with getting away with it? Can I? Jesus Christ! Okay. From a purely legal perspective, it shouldn't matter. Because what should matter from a purely legal perspective is what's in the record and what's not. And what happened at what it doesn't matter. He's the question trying to change the record, and I take exception. Okay, never mind. It's fine. It's all fine. Let's Justice Breyer, tell us more.
Site with the policy put up before or after. It was either before, after, or instantaneous. I mean, what was it?
So there are just a couple different documents, and to clarify, the policy and the goal and the rules that are incorporated by the policy was adopted in October of 2018. The website that refers to the goals, it is not in the record at what time that was adopted. In the stipulation of facts, the parties have discussed it in the historic section, not with the new policy and rules, but the record is silent on that.
That's not an answer.
Justice Alito?
Okay.
Nope.
Justice Sotomayor?
No, thank you.
Justice Kagan? Justice Barrett? No?
I'd just
Thank you,
like to
counsel.
say that this is absolutely, in every possible way, one of the best oral arguments I've ever heard in the Supreme Court. I mean, I could have been more persuaded by Boston in every possible way when we're talking. And man, oh man, just it's nice to have advocacy. You know, one of the things I crave, and one of the reasons I do this entire Supreme Court React series, is because I want the absolute best of oral argument. I want to raise myself in almost a religious fashion, to be quite honest. I want to extol myself upon the greatest manifestations that this practice has to offer. And let me tell you, the city of Boston, man, wow.
You know, they started off I thought they started off fairly strong because they're framing.
No, this is absolutely non-sarcastic in every way. Absolutely non-sarcastic. They started off great.
Yeah.
They started off great.
But
and there was some great stuff.
As soon as
they started some great stuff,
it.
and they had some tension there, where they're pushing some boundaries, and there was some, in the first two, they had me in the first half. So let's just pretend nothing past the first half happened. It'll be great.
I would just like to point out for everyone that was one of my first questions, was whether or not they had talked about the Establishment Clause yet, and as it turns out, that was the key question. So, because that's when everything changed, right? The Supreme Court was like, well, isn't this really an Establishment Clause issue, and isn't this actually relatively simple in that case?
I don't even know if this is an Establishment Clause question. This is.
I mean, but that's what Kavanaugh asked, and that's when was it Sotomayor or Kagan that just was like, hey, yeah, actually,
no,
your guy made a mistake.
No, this is a what are women question, because that's how bad it is. It's because we can't even fucking define our terms. Women, if we call women by a different label, it totally makes a difference.
Chat is
this
saying
is not working
Kagan.
For you, or are you just ignoring me because I'm bigoted, or what?
No, sorry. I got distracted in the chat. It was Kagan that had asked that.
No, there was something so fundamentally broken. It broke. Maybe this wasn't clear before. I'm sorry if it wasn't clear, but it raised a little bit of mental distress with me. I couldn't quite.
I didn't notice.
Parse what was going on.
I don't think.
And maybe it was a little
either.
bit vague or some ways. I mean, it's just a little bit. It's just like some little bit of inclarity that raised a little bit of question in my mind.
Yeah. I think it may have been just somewhat concerning, right? Just a little bit, like not too much, but like, just a little bit of a wavelength. Should we listen to the rebuttal?
Sure.
Rebuttal, Mr. Staver.
The record does reflect that at the time of 2017, the website was in effect. In fact, that's what Hal Shurtleff used. And the policies specifically written by the city for the 2005 to 2017 include the statement that these are public forums open to all applicants. And that's the application that still is there, and it's still being used, and it's the same exact guidelines in 2017 as it is now. In 2019, in page 30, footnote of our brief, we indicate that during an interrogatory, the city confirmed that all the policies that were on the website in 2017 are still there, and they are still used. So in 2018, they adopted the policy that's in the joint appendix before the Court of Appeals, beginning at page 569 to 570. That particular policy does not limit subject matters or speakers. It says it's open for any event or occasion. Clearly, Camp Constitution celebrating Constitution Day and Citizenship Day was one of those occasions and or events. That same flag could have flown, but for a mistaken view of the Establishment Clause. And that Establishment Clause caused the ultimate problem. To justify that mistake, they argued that it was government speech, and they're bound to censor. But it's very clear that the same flag could have flown with the same exact symbol for the same 1 hour event without any incident had Camp Constitution simply lied and said this is not the Christian flag, it's the Camp Constitution flag. They were actually encouraged to actually have a non-religious flag or rename the flag. The reason why it was censored is solely because...
Well, no, stop. You can't be serious. Are you serious? Did I miss a memo, or are we fucking serious? Because what he's saying right now, and I'm coming into this cold, so I don't know, but what he's saying, they were actually encouraged to have a non-religious flag, or Rename the flag.
I want to know who encouraged it.
So let me make sure I understand. Not only did they call a rose by another name,
By a potato.
but they were told, hey, if you merely call this a rose.
No, if you call this rose a potato.
We'd allow it. They wouldn't do it. And because of that reason, we denied them. That's what we're going with.
Yep.
And the First Circuit ruled for Boston with this fact pattern.
Yeah.
Alita?
Yes. Yes, Kurt. Are you disappointed in the Second Circuit?
First Circuit, and at this point, I think I'm ready to appoint myself as a federal judge. I don't want to be overly pompous, but apparently I'm ready to be on the Court of Appeals for the First Circuit. Because I think my trained gopher could have gotten that one wrong, right? But, yeah. This is, I'm going to die. Which is not good for me being appointed, because they don't allow dead people on the Court of Appeals, but
They
yeah.
generally don't.
I think one of the biggest disappointments maybe from watching a lot of these trials that we've been watching is I feel ready to be a litigator. It's like I can do better, and I've never had practice. It's like I can't fuck it up worse than some of these people. I might do as poorly as some of these people, but how can I fuck it up worse than some of these people?
Yeah.
And I look at this decision from the First Circuit, and I'm like, I may not be as smart as them, but how could I possibly fuck it up any worse?
Yeah.
So it's like I'm ready. I'm ready to be a federal judge. I'm ready to be a federal litigator. I'm ready to be on the goddamn Court of Appeals, Alita.
Let's start a firm.
I don't know if starting a firm will solve the problem, because what happens if the firm is smarter than the Court of Appeals?
Well, then, I mean, ideally, that firm is able to convince them.
Well, we'll have to change our argumentation strategy. We'll have to say, look, pretty crown. These are some pretty crowns. Here's some sparklies. Would you like some sparklies? Shiny ball. Would you look? Ooh, I have your nose. So we may have to radically change the nature of what a law firm looks like, but I'm in. How much longer do I have?
Not much longer. We're talking about the oral argument, right? There's only a few minutes left, I think.
I don't know. Am I talking about
because of the word Christian, and that is clearly viewpoint censorship. The question here is who is speaking. And by policy and practice, it's very clear. It's not the government. They didn't exercise control. They did ministerial review. They never requested a flag to be changed. They didn't own them. They didn't initiate them. In 2018, the policy says that any individual or organization may apply, and the only viewpoints that would be censored would be those that they deem to be inappropriate, offensive in nature or those supporting discrimination or prejudice or religious movements. Apparently, you could be anti-religious movement and be permitted. But what they clearly indicated is in 2018 what they had done in 2017, and that is it was an all-comers policy, no subject matters, no speakers, limited, but one particular viewpoint they are going to exclude, and that viewpoint happened to be a Christian or a religious viewpoint. They raised the Establishment Clause mistakenly to justify their decision. But this case cannot fall under government speech. The error of the First Circuit was to begin with the idea — I see that I'm out of time.
Finish your —
The error of the First Circuit, Mr. Chief Justice, was to begin with the notion that you can never have a flagpole forum. And then they crammed everything else into government speech, foregoing the traditional analysis of public forum doctrine. Thank you.
Thank you, counsel. The case is submitted.
I think this is going to be 9-0. At the very least, I don't know, 7-2. What do you think? You all right, Kurt? Kurt, are you rebooting? Control-Alt-Delete. Control-Alt-Delete.
So I think this is a reverse. I think this is a strong reverse. Depends a lot on how narrow the Supreme Court wants to write it. My thought is it's going to be more of a 9-0 variety. And I'm going to go commit seppuku now. On behalf of my profession.
Please don't do that.
One less lawyer in the world will be a good thing.
We need you, Kurt.
I try to be. People in the chat may disagree with this, but I try to be humble. I try to be open-minded. I try to listen, and I try. Yeah. When I see a strong point, I'm like, geez, there's some tension here. Mm-hmm. And then I get to this shit, and I'm like, holy shit, I'm ready to overtake the fucking world. Holy God.
But this is why framing is important. When you frame an argument, that really, I mean, everything else rests on top of that framing.
I can't believe it. I'm trying. The only question I'm trying to decide in my mind at this exact moment is which is stupider, this or the last 3 minutes of the BL versus Mahoney argument.
Are you referring to the high school cheerleader? Yeah.
Yes.
That one was worse because my brain exploded on that one too because it just.
Is your brain remaining intact on this?
I mean, I much more appreciate the strategic moves and just the way. I mean, I can appreciate the city of Boston and council's ability to just try to maintain course, try to correct things onto like, okay, but don't go over there, don't look over there, but like bring it back over here.
They call it something else, but they call it a Christian flag. The problem is they called it a Christian flag. If they called it something else, we would have approved it. The thing is, they called it Christian. We don't like Christian. We disapprove the word Christian. Christian.
They were trying to say
because they call it Christian. They call something else. They call it Christian.
They were trying to say, well, we don't want to be commenting on religion, right? Because Establishment Clause, which is not a correct assessment of the law. But this is just
brand new when I started. You know what? I'd just like to say this bottle was brand new and it's looking almost halfway.
I mean, I'll say so. Number one, I can appreciate this attorney's ability to maintain course, maintain his position. I think he did a good job of that, and I can completely respect that. He didn't just like give up and be like, well, actually, you're kind of right there. He did a good job for the job that he had. And I think that this is just one of those cases. It's kind of like looking at any sports match.
He did a good job for Durr.
What's that?
Durr. You did a good job for Durr. They called it a Christian flag, and I are a Christian flag.
But I mean, but at the end of the day, the other side just has better arguments. Once you take a look at that real part of the factual scenario, that they were like, well, if you had just not called it a Christian flag, I mean, that is really the ultimate nail in the coffin for the city of Boston in this case. I mean, as soon as they came across that point, that was it. Their case was sunk.
I'm not sick, but I'm not well, and I'm so hot because I'm in hell. Yeah. Paranoid, everyone's coming to get me. Say you never met me. Running underground with the moles, digging holes. Swear to God, it sounds like they're snoring. More than you're boring. The agony and the irony, they're killing me, yeah!
That's what I'm really here for, is just the karaoke.
Okay, well, we didn't hit our 50,000 goal target tonight, so that's a little bit disappointing, but
hey, we'll get it.
Don't forget to check out my friend Legal Bites. I'll make sure to pin her channel in the comment, probably tomorrow, to be quite honest at this point.
Apologies for my
yeah, no, it's fine. It was a
really
miscommunication.
bad
Check out her.
tardiness.
She's grown. Where are you? Because you're at 42, 43?
41.
Yeah, somewhere around there. So make
Yeah.
sure to check her out as well, because she does some legal analysis one bite at a time.
Yeah.
Make sure to do all the YouTube things here. I've been on civil law. This has been fun. My prediction is reverse. Probably 9-0.
Yeah.
It depends a little bit on how they write it. If it's more of a fact-specific 9-0, if it's a little bit more general, 7-2.
Yeah.
So take your pick between those two, and if it's anything other than that, then I'm giving up doing the channel. It's been fun already.
Thank you for having me.
Yeah. Until later, my friends. I hope all's well. Peace and good night.
See ya.
And we're out.